please always give them my best.
Absolutely.
I keep meaning to reach out. I think she became a county judge up there in
Yes,
Hillsborough.
she ran.
Yeah.
She ran up there. I was very happy about that. Like
Yeah, because she's not necessarily, I don't think, has connections or has great wealth or so
no. And she was one of the prosecutors that you could deal with. You know, there were some of them up there that
had some reason and some perspective.
Yeah. There were some of them up there that did not.
Do each of you have a proposed packet in front of you?
Yes, Your Honor.
Yes, Your Honor, and this is from the email that Ms. Frablin sent yesterday. But I have it open to make any edits.
Great, let's take a look at it. Introduction to final instructions. We'll go page by page. Any objection to this by either side?
No objection, Your Honor.
No, Your Honor.
3.2, now let me just remind, just so Mr. Tower understands. We're having this jury instruction, we call it a charge conference. We're having this early because time allows us to have this discussion. This doesn't mean these are permanent. There could be changes that happen based on the additional evidence presented. For example, once the state closes their case in chief, your attorney will make arguments. So we haven't had motions yet. So this is an early look at jury instructions, Mr. Tower. This isn't a final discussion. We'll have another discussion once we've closed all the evidence before we were to read this to the jurors, okay?
Your Honor, just a question. Do you prefer like page numbers in the jury?
No, I don't need page
Okay.
numbers. Does the defense have any preference? My preference would be not to do page
Okay.
numbers.
Perfect.
I would not like them
Yeah.
either.
Okay.
All right, next is statement of charges. Again, in this case, we had the defendant was indicted on 2 counts of first-degree murder. I granted the state's motion to consolidate those 2 counts with the fleeing to elude. Because he was indicted with first-degree murder, the second-degree murder charges that were initially filed were declined. I think there was a written order to that effect, not order, but motion by this memo by the state. Is that right, Emily? Did Ms. Frabling bring something over to you on Wednesday on the second-degree murder charges?
Yes, but I believe there needs to be further clarification.
Further clarification, okay. So these,
Oh, wait, it was clarified, yes.
it was clarified.
Reflecting.
All right, so these appear to me to be the statement of the charges that the court allowed to go forward on. Count 1 is murder in the first degree. The state identified Mr. Gilman to make 1 and 2 unique. They put in the alleged victim.
Yes, Your Honor.
I think that that's appropriate. Do you have any objection to that?
I do not.
And then count 3 is fleeing to elude. They also inserted here to identify it siren and lights activated. Again, we'll get to that later, but they're lesser included. So I think that's appropriate. Any objection to the statement of charges page?
No, Your Honor.
All right, next we have 7.1, introduction to homicide. Unless expressly waived by both parties, this must be read in all homicide cases. I've reviewed it. The state just inserted the correct pronouns. They do have Mr. Gilman, both lesser included counts of murder in the second degree and manslaughter inserted. And they have the defendant's name, Dima Tower, inserted as well. It appears to me, as I went through it and compared it to our Supreme Court version, that it's legally accurate. Do either side have any objection?
No, Your Honor.
No.
All right, next we have 7.2. This is the instruction on murder first degree. It has the statute number. I have compared this to the Supreme Court version. It appears to be legally accurate. It has the defendant's and the defendant and alleged victim's names. Now they're all capitalized. The state has been consistent throughout doing that. Is there any objection by either side to that? To capitalizing the names? I think it's usually done. I can't think of any prejudice to capitalizing the
No.
name. It's not in any way.
I don't think I have any objection to it, Your Honor.
And I'm going to see.
All right, any objection to this instruction as it relates? So this is count 1. This is with Jennifer Tower as the alleged victim.
No objection, Your Honor.
No objection.
All right, count 2. It's the same exact instruction, except if you look at element 1 and 3, instead of Jennifer Tower, it now has Robbie Tower, which is consistent with the state's indictment that Robbie Tower is the victim, alleged victim in count 2. Any objection to this instruction?
No, Your Honor.
Next is 28.7. Again, I did already compare these to our Supreme Court version. I found no mistake in this either. Names are capitalized, the defendant's name is inserted, there's no victim name here. It has the definitions, it has the 3 elements correctly outlined. Any objection to this by either side?
No, Your Honor. The only issue is there is I don't know if you want to take the brackets out of the vehicle definition.
I definitely think we should. I
Yeah.
missed that. Yeah.
I'll take
Thank you for catching that.
Yes, Your Honor.
All right, let's address the lesser included crimes to count 1. They are murder in the 2nd degree and manslaughter. Are either side requesting those?
Yes, Your Honor.
Okay. Yeah, I think it's appropriate to include these. The state appropriately did here. So we have murder in the 2nd degree and manslaughter. For fleeing to elude, the 2 lesser includeds in the definition are fleeing to elude without sirens and lights and reckless driving. Are either side requesting either of those?
No, Your Honor.
State?
So defense is not requesting any lesser included for
The fleeing to elude?
the fleeing to.
Correct.
Okay. We'll request the first, the felony fleeing to elude.
Okay. So you want to make the argument that there were no lights and sirens activated. Okay, let's keep in fleeing to elude without lights and sirens. Both sides agree not to have reckless driving. State defense?
Correct, Your Honor.
Okay, we'll remove reckless driving. All right, so we now have the definition. So we're now going to get into the lesser includeds. The state did one, which is probably appropriate for each count 1 and count 2. So the first one is murder 2nd degree. They inserted victim Jennifer Tower. So this is the lesser included for count 1. I compared it to the standard instruction. It's legally accurate. The portion that's in the standard instruction that the state is not included is the whole discussion on negligence. Do both sides agree that does not apply?
Yes, Your Honor.
Yes.
Yeah, I agree as well. Any objection to this instruction?
No, Your Honor.
Yeah, I think it's legally accurate. Again, I compared it to the Supreme Court version, and it is the same. All right, next we're still on count 1 now. The lesser included crime is manslaughter. They inserted victim Jennifer Tower again. It shows to the jury that this is still count 1. It has the 2 elements. Again, I compared this to the book. It is accurate. Any objection by either side?
No, Your Honor.
All right, we're now moving to count 2. This says victim Robbie Tower. Count 2, 2 first-degree murder is 2nd-degree murder. It's the same instruction as the lesser included is to count 1, although instead of Jennifer Tower, we have Robbie Tower inserted. Any objection by either side to this?
No, Your Honor.
State?
No.
Okay, we also have the manslaughter instruction for count 2. This is the victim Robbie Tower. They inserted the defendant's name, victim's name. Otherwise, it's the same instruction. Any objection?
No, Your Honor.
All right, we have the lesser included for fleeing to elude, which is fleeing to elude. Any objection? Oh, we need to do what Mr. Gilman pointed out before. You still have the bracketed part in the vehicle definition. Can you remove that?
Yes.
Once that's done, any objection to this instruction?
No, Your Honor.
No.
All right, reckless driving will be removed. Good morning, Ms. Frablich.
Good morning, Your Honor.
All right, next in my packet is 3.7, plea of not guilty, reasonable doubt, and burden of proof. This appears to be the old version. We need to get the updated version, 2025. The only difference is that in the paragraph that begins, a reasonable doubt is not a mere possible doubt. That paragraph has changed, and that paragraph now begins, proof beyond a reasonable doubt does not mean proof beyond all doubt. Are you able to get the updated version?
Yes, Your Honor.
Other than that, it's the same. All right, once that change is made, is there any objection by either side?
No, Your Honor.
Okay, I'll give you a moment, Ms. Whipple. Let me know when you've finished that.
All right.
Okay, next I have 3.9, weighing the evidence. Okay, we have 1 through 5 that are given in all cases. So what we don't have is 6 through 10. So let me just read them out loud and let's see if we think so far any apply or if you can anticipate perhaps. Number 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
I would not think that applies.
State?
Agrees.
All right. Did you say agrees?
Agrees, yes.
Okay.
I
All right, so right now we think 6 does not apply. 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony?
I do not anticipate that testimony either.
No, it doesn't apply, Your Honor.
Okay. 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? I don't think we've had impeachment so far. We'll see how it plays out. I think we have, we'll see how the rest of the trial plays out. But so far we agree it wouldn't apply.
Correct.
All right. 9, has the witness been convicted of a felony or a crime of dishonesty? There's been none of that so far. We'll see if that changes for the remainder of the trial. 10, does the witness have a general reputation for dishonesty or truthfulness? There's been no testimony related to that. So far I would agree that 6 through 10 don't apply. We'll have to readdress this at the end of the evidence. All right, whether the state has met its burden remains in. The fact that a witness is employed in law enforcement, we give in all cases. Expert witnesses can remain in. We didn't have any accomplice or informant, so that was correctly not included. There's been no child witness. We'll wait to see if Mr. Tower testifies, whether or not to include that or exclude it. Proper for a witness to talk to the lawyers and relying upon your own testimony. So this appears to me to be legally accurate right now. The only issue is when we find whether or not Mr. Tower testifies, we'll address that. The next one, 3.9A, defendant not testifying. We'll wait to see what Mr. Tower chooses to do. 3.9B, defendant's statements. We have that here. We have a statement that was played to the jury yesterday. This is something the jury should take into consideration, this instruction. I've compared it to the Supreme Court version. This appears to me to be legally accurate. Any objection by either side?
No, Your Honor.
No.
3.10, rules for deliberation. All of them are included except the jurors talking about questions they asked. Of course, they didn't in this trial. So this appears to me to be legally accurate. Any objection by either side?
No, Your Honor.
No, Your Honor.
Cautionary instruction is legally accurate. I will read that, of course. 3.12A, we have single defendant, multiple counts. Can you get rid of and informations in the title portion there?
I just called it charging documents.
Can we just get rid of it?
Yeah.
I think single defendant, multiple counts is the issue that the jury, we're honing them in on here.
Thank you.
So let's see, you have a separate crime is charged in each count of the charging. Can you make that singular document? I granted a motion to consolidate, so we don't need them to be thinking that we have an information and an indictment. I think that's irrelevant.
Yes, Your Honor.
But we do need them to know that there's multiple counts and they need to consider them separately. So let's see. A separate crime is charged in each count of the charging document. You're getting rid of the S. And although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. This now appears to be legally accurate to me. Any objection once we remove and informations and the S in documents?
No, Your Honor.
Okay.
Your Honor.
Ms. Whipple, were you able to make those changes?
Yes, Your
All right, the verdict instruction 3.12 seems appropriate. Any objection?
No objection.
All right, verdict looks good to me as well, that the state listed, I think, appropriately consistent with the jury instructions. They listed the alleged victim to identify the difference between count 1 and 2. They have the lesser includeds. It's perfectly lined up. There's nothing italicized or drawing attention to anyone in particular. Guilty and not guilty are not capitalized throughout.
Count 3.
Your Honor, I did, for count 3, that this isn't on your section. Initially, there wasn't the lesser included, but can I talk with Ms. Frabling for a second?
Sure, about whether you want the reckless or...
There's something that has to be changed about the title. It's called fleeing to elude. I have attempting, and that has to be removed. Defendant is guilty of fleeing to elude law. Or what happened? Did we?
So, earlier when we were going through potential lessers,
Yeah.
Mr. Gilman said that he was not requesting the lesser fleeing or the reckless driving.
Okay. Okay,
Because
great.
I had said initially maybe the lesser included of the fleeing to it, or do you want, no lessers at all?
No lessers.
No lessers?
Yeah.
Okay, so then.
All right, so what we're gonna do though, Your Honor, is take away B and C.
Well, there's currently only B.
I might have a different version, but so right now I have A, B, D. So
Right.
A would be the defendant is guilty of, let's see, how do you have it labeled on you? It'll be the defendant is guilty of fleeing to elude law enforcement officer, parentheses, sirens and lights activated. So it's consistent, I think.
Yes. and
As
then-
charged. And then B would be the defendant is not guilty.
Yes, we just consulted and the state is no longer requesting a lesser.
Right, I heard you.
Okay,
Yeah, I think we all, yeah.
Or attempting.
Mr. Gilman, did you hear that?
I did.
Okay, so it's gonna be A, B. And you're just gonna include lights and sirens, although just to be consistent. And then it has the correct month, year, place to be signed. It looks legally accurate. All right, let's discuss this now. They have your last page, submitting case to jury. Talking about what evidence would go back. Can you get both, Emily, can you pull out both knives for me? The ones that are not the butcher block. I don't want the butcher block. So my thought, folks, on evidence that can and cannot go back to the jurors. My thought is the butcher block with knives loose should not go back to the jury. That's too much of a danger. I could tell them that if they want to see that, they could just send a note. We can bring them into the courtroom, and we could have that shown to them. The question is on these two items, whether they're secure and safe to go back to the jurors. What are your thoughts?
May I take a quick look?
Yeah, come on up. And Carl, you can express your concerns and thoughts. I think the bailiffs are hesitant to allow those to go back.
This is very easily can come out of this with no problem. Yeah.
Not only that, Your Honor, there is biohazard on there, so we can tell the members of the jury.
Oh, that's true. There's alleged blood on there, right?
It's not going back because of biohazard, but if they wish to see it, they can view it in front of all of us with the bailiff showing them again. They're all photographs of this evidence, so.
Mr. Gilman, what's your position? Are you okay with that?
I'm fine with that, Your Honor.
You are?
Yeah, and again, there's photographs of everything.
Okay.
So if it's a safety concern, I have no problem with them just having the photographs.
And the state's okay with that?
Yes.
Okay, that's what we'll do.
So no butcher block, no knives.
What I'll do is I'll explain to them. So let's see, let's look at our jury instruction. During the trial, towards the bottom, folks. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. A, and here's the options for us. A, some of these exhibits will be sent into the jury room with you when you begin to deliberate. And B, if you wish to see any other exhibits, please request that in writing.
I think both of those would be
They
appropriate.
apply. So let's just keep it the way it is. and I'll explain to them the only items that are not going back are the knives. And I'll explain that to them, that they just need to put that in a note, and we could bring them in here for them to see it, okay? All right, so 3.13, submitting case to jury, it's fine, the instruction as it is. I have the closing argument instruction. You don't need to give that to the, you don't need to include that in the packet that goes to the jurors.
We'll take it out.
Are there any other instructions either side are requesting?
No, Your Honor.
No, Your Honor.
And I can't think of any other instructions that apply as well. All right, so State, if you can make those changes, if you can send a copy to me and Mr. Gilman so we can have at least our updated version. We'll address it again at the close of the evidence. It's 9:22, we'll be adjourned. If you can be ready to start the trial at 11.
Yes, one thought, Your Honor. Do we want to discuss now, there is a DVD of the defendant's interview. The jury may wish to listen to that, or also the 911 calls. Did we want to talk about?
That all goes back to the jury. I mean,
Right,
to the,
but do they, are you going to explain to them how they can play it and do that sort of thing?
what I do is I bring IT in to just explain the jury card. I like to have that on the record, that the jury card doesn't do anything. It doesn't have access to the internet. All it can do is play the evidence. So I'll bring in Kevin or Henry, someone from IT. They'll wheel it in. They'll explain to them how it works, which is basically just a mouse, and all they can do is stop, pause, fast forward. And then I'll have Henry wheel it into the jury room.
Thank you.
Okay?
Yes, Your Honor.
Good.
All right, have a nice break. Let's be ready to start the trial at 11 o'clock, okay? All right.
Rise, for recess.
back to Court TV Live. I'm Ted Rollins in for Julie Grant on this Thursday. This hour we are in Colorado for the father figure murder trial. Prosecutors say that the defendant, Darren Thrailkill, strangled to death his girlfriend's 6-year-old little boy named Martin nearly a decade ago. But the defense says Martin had asthma and other complications, and that's what led to his death. Here's more from the defendant's ex-wife on the stand.
Ladies and gentlemen, with regard to the evidence you're about to hear, I'll give you this following instruction that you're to follow. Evidence of any other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in conformity with the character, but can only be used for the following purposes: identity, motive, intent, or lack of mistake or accident. And that was the same instruction I gave you with regard to Ms. Osinski's during a part of her testimony. So I'll just refer you back to that for that same language. I think you all took it down a second time and we went through it pretty closely. So thanks. Ms. Mayor?
Thank you, Judge. Ms. Thrailkill, on March 26th of 2012, did you contact Delta County Sheriff's Office to report possible child abuse?
I don't remember if it was Delta County or Grand Junction.
Okay. Do you recall Sean coming home from a visitation and observing injuries?
Yes.
Judge, if I may approach, I've shown defense counsel 1100 through 1107.
Sure, thanks.
Ms. Thrailkill, I'm showing you what has been marked for identification as People's Exhibit 1100, 1101, 1102, 1103, 1104, 1105, 1106, and 1107. Have I shown these to you prior to coming into court today?
Yes.
At least as regards to 1100 and 1101, what are those photographs of?
The trailer that we lived in?
And what trailer number was that?
251, I was wrong.
Ultimately, after you contacted police, did a Grand Junction police officer actually come to your home and do photos while you were present?
Yes.
Do these appear to be the photos the officer Travis Wright took?
Yes.
Are 1100 and 1101 fair and accurate as to where you were living at the time?
Yes.
People would move for admission of 1100 and 1101.
Ms. Parham, do you have an objection?
We just maintain the previous objections we had to this evidence.
Okay, the objections are overruled. 1100 and 1101 are both admitted.
As it relates to the other exhibits, is 1103 a fair and accurate representation of what Sean looked like the day the officer came out to your home?
Yes.
And are you actually in this photo holding him?
Yes.
People would move, is this fair and accurate of what Sean looked like?
Yes.
People would move for admission of 1103.
Any objection to 1103?
We just maintain our previous objections to this evidence.
The objection's overruled. 1103 is admitted.
And as it relates to these other photographs, do these appear to be fair and accurate representations of the injuries that you remember existing across Sean's torso?
Yes.
Are they a fair and accurate representation from what you remember?
Yes.
People would move for admission of 1102, 1104, 1105, 1106, and 1107.
Ms. Parham?
We'd maintain our previous objections and also object to the number of photographs as cumulative.
Can I see those exhibits, please? Thank you. Thanks. The objections are overruled. 1102, 1104, 1105, 1106, and 1107 are all admitted. Sure.
We could first publish 1100. This is where you lived on 25 and a half Road.
Yes.
And if we could please publish 1103. Is this what Sean looked like March 26, 2012?
Yes.
And you indicated, is that you holding him when Officer Wright took this photograph?
Yes.
And if we could please publish 1102. What do you remember about his injuries?
They were deep. It took up most of his backside. And they were very wide.
And if we could publish 1104. And this would be his backside.
Yes.
If we could please publish 1105. If we could publish 1106. So we're looking at Sean's left side. Basically, we've looked at from his back around to his front side. Is that right?
Yeah.
And if we could publish 1107. Thank you. When Sean returned home, did you follow up by taking Sean to a doctor?
I did.
Was that Dr. Whistler at Western Colorado Pediatrics?
Yes.
Were you aware of whether or not CPS got involved?
Yes.
Were you aware of whether or not they interviewed Sean about these injuries?
Yes.
I don't have anything further. Thank you.
Ms. Parham, any cross?
Yes.
Okay, whenever you're ready, thanks.
Okay, they get set for the cross. Matthew Mangino, boy, this is huge for the jury to hear. Prior incident, other kids abusing. It is a game changer for the state. What is the bar for this to be let in? Because this is an incident that didn't have anything to do with little Martin's death, you could argue, and the defense, I'm sure, opposed this vehemently in pretrial motions. How does the judge weigh what shouldn't come in something like this that is, it's a game changer because it's showing the jury the true colors of this individual?
Well, right, Ted. It's showing, prior bad acts, and specifically, it's showing conduct which amounts to child abuse, and that's the focus in this case that ultimately led to the death of a 6-year-old, which indicates that this death was a homicide. So these prior bad acts shows some pattern of abuse of children, and as you said, it's devastating for a defense. I'm sure the defense fought this. There's a curative instruction which was given to the jury, or cautionary instruction. But the bottom line is this jury just heard that the defendant has a history of child abuse, and they're listening to a case about the death of a 6-year-old. So it is devastating to the defense.
Yeah, there's no, I can only imagine jurors sitting there watching this, looking at those photos of the boy's back, and then just turning their attention to the defendant with disgust because he's convicted right there from the ex-wife of abusing a child, and then the 6-year-old magically dies in your care. It's game over.
Yeah, I agree. I mean, I've been involved in cases, excuse me, where, prior bad acts have been at issue, and you literally fight tooth and nail to keep that out because you know that, jurors are human. They're going to listen to this and wait. They're going to hear some sort of consistent pattern of abuse when your client's being tried for murder of a 6-year-old. As you've indicated, and I agree, this could be the end of the show for the defendant in this case.
Yeah, well, let's get a break. When we come back, we'll have the cross. See what the defense attorney tries to do with the ex-wife to maybe change the narrative a bit. We'll see how that goes. Plus, a live look into the courtroom in Florida. They're done with their charge conference, meaning next up is more testimony in the adopted son murder trial for Dima Tower. Stay with us.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
All right, help party, I'm dying.
Don't you have the blood of both these men on your hands?
I felt guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
On July 2nd of 2016, is that a date that sticks out in your memory?
Yes.
Why?
Lost my baby.
Did defendant Darren Thrillkill remain a parent-like figure in Martin's life on that date?
Yes.
Court resumes in the father figure murder trial later today for Darren Thrillkill. He's accused of killing 6-year-old little Martin, his girlfriend's son. Prosecutors believe he reached a breaking point after the child had a bathroom accident. The defense is saying, well, the poor Martin had pneumonia and asthma, and that's why he died. Right now, we're listening to key testimony in the state's case. The defendant's ex, just on direct examination, detailed with photographs how the defendant had abused one of their kids. Now it's time for the defense to try to rehabilitate the defendant through the ex-wife on cross. Let's see how they do.
And this report was made at the end of March 2012, right?
Mm-hmm.
And sorry, can you say?
Yes.
And that was at the beginning of, or I guess the middle of a divorce with Mr. Thrillkill.
Yes.
I think you all had separated in December of 2011.
Yes.
And there was a contentious, or I guess it was a contentious divorce and custody case at that time.
Yes.
And the day after you reported this, you requested a copy of the report to use in the custody case.
Yes.
And you remember talking to DHS, right?
Yes.
And there were several days between your initial report and when DHS came out to talk to Sean.
Mm-hmm. Yes.
And he was staying with you during that period.
Yes.
And Sean said different things about what happened.
Yes.
And you heard different things about what happened from different people.
Yes.
You were at the house when Sean talked to DHS.
Yes.
And you believed you irritated them by trying to, quote, help Sean along.
I don't know.
Okay. Do you recall speaking with the district attorneys, and their paralegal, Ms. Weimer, on October 16th, 2025?
Yes.
And during that interview, you indicated that you believed you irritated DHS by trying to, quote, help Sean along, end quote.
Yeah. I don't remember, but yes.
Okay. And you were married to Mr. Thrillkill for several years, right?
Yes.
And the only kind of physical discipline you ever saw was spanking.
Going to object beyond the scope of direct examination.
Ms. Parham?
I think this fits well within the scope of direct examination.
The objection sustained.
And so this isn't the only time you've talked to DHS, right?
Yep. Yes.
And after Martin's death in 2016, you spoke to DHS several times.
I'm going to object again beyond the scope of direct examination by years.
And these statements get into the credibility of this witness. She gave multiple inconsistent, reportedly false statements to DHS in 2016.
I'm going to object to counsel providing a narrative. If the court would like to handle this at the bench, we're objecting as to outside the scope and relevancy.
Okay, if you can approach, thanks. Feel free to stretch.
All right, sidebar there, Matthew Mangino. The defense strategy here, obviously there's more to the story about the abuse photos, and you're a liar, because in a contentious divorce, people do anything. Is it going to work?
Well, that was an interesting interaction there. If I was objecting to that, I would have asked for a sidebar immediately so I could explain that I believe this is outside the scope, in anticipation that the response to that might be, hey, she's given inconsistent statements in the past. That's in front of the jury now. Although it's just a statement from counsel in response to an objection, it's still there. And the jurors have heard that this witness allegedly made inconsistent statements in the past. And that's a credibility issue that hasn't been formulated through testimony, but by argument of counsel. That's why you don't make objections necessarily in open court, because you can elicit responses like that that could be harmful to your case.
Oh, yeah. I mean, that was huge. The defense attorney was able to blurt that out, and now the jury's looking at this lady with a little side eye. Are you lying? The photos, though, of a boy with injuries to his back, and he was in the care of the defendant at the time. Boy, I don't know. I don't know if this surpasses it or erases it, but I think that the defense is doing a good job, and the prosecutor missed the beat there. What now? If you're the prosecution, you really have to be on guard for the defense to continue down this road, correct? And so at sidebar, what are you telling the judge?
Well, I'm telling the judge that this is not really relevant to the case, that these issues could have been examined pre-trial in motions in limine and other things like that. Now, we have photographs, we have other supporting documentation. It's not really an issue of credibility with this witness. It's the photographs, the history of abuse speaks for itself. The defense is going to try to attack her and say that she's not credible. But how do you get over that hurdle of, hey, here's photographs of abuse, and there were charges that resulted from that abuse as well?
You put Thrailkill on the stand to tell his version of the story, saying I didn't do anything to little Martin, or is that like a lot of defendants, a can of worms?
Yeah, that's a can of worms, because he gets up there and says something to the effect of, I would never harm him, and then all of a sudden, boom, all this other conduct of yours is relevant in terms of your the defendant's believability and credibility. So yeah, it would be a risk, but you have to evaluate the case before that decision is made, and ultimately it's the defendant's decision, not counsel.
Sure is. Matthew, thank you. As always, let's get a break. We'll have more Thrailkill out of Colorado when we return. Stay with us. This morning we were in Colorado for the father figure murder trial. Prosecutors say that the defendant here, Darren Thrailkill, strangled to death a 6-year-old little boy by the name of Martin. He was the boy of his girlfriend at the time. This was 10 years ago. The defense says that Martin suffered from asthma and other complications, and that's why Martin died. We're watching some key testimony here. The defendant's ex-wife's on, and she told the jury about an incident with her kids and this defendant, and showed photos of bruises and marks on the back of a youngster. Now she's on cross, and the defense is trying to make her out to be a liar. They've just finished up a sidebar. Let's go rejoin where we left off.
And so you spoke to DHS workers several times during their investigation in 2016 after Martin Osinski died, right?
Yes.
And during your conversations with workers at that point, you talked to Jackie Berry on July 7th, 2016.
Yes.
And you told Miss Berry that you intended to kick out your then boyfriend, Zach Boiler.
I'm going to object. This is hearsay. She's not impeaching her on some other statement. This is hearsay.
Ms. Parham.
I'm not offering it for the truth of the matter asserted, and I'm offering it because it goes to the credibility for the reasons I've previously stated.
Okay. The objection's overruled. The jury's not to consider it for the truth of what's asserted in the statement, just for the purpose articulated by Ms. Parham and concerning the witness's credibility. Thanks.
And so when you spoke to Ms. Berry on July 7th, 2016, you indicated that you intended to kick out your then boyfriend, Zach Boiler, right?
Yes.
And then the next day, you also spoke with Ms. Berry.
I don't remember the exact dates, but yes.
That's fair. But you reported to Ms. Berry that you did, in fact, end your relationship with Mr. Boiler.
Yes.
And you are married to Mr. Boiler.
Common law.
You have a baby with him.
Yes.
You did not end your relationship with him.
No.
During the 2016 investigation, you also were in contact with Officer Gregory.
I don't remember the exact officer.
Oh, I'm sorry, I misread my notes. And so in 2022, you spoke with Officer Gregory, right? And that's when you reported that you had this baby with Zach Boiler.
Yes.
And you asked Detective Gregory not to tell Natalie Freeman.
I don't remember that.
And so I guess you indicated previously, going back to the incident in 2012, that you had information about conflicting statements from various people about how Sean got his injuries, right?
Restate that, I'm sorry.
And so you indicated previously regarding the 2012 incident that there was conflicting information that you received?
Yes.
Okay. You had information that he got the injuries from falling on a toy box?
I'm going to object to the hearsay. If she is intending it to be relevant that there was conflicting information, she's answered that. We don't believe the underlying hearsay is admissible.
Ms. Parham.
And I was just following up on the previous information that Ms. Thrailkill indicated that she had about conflicting information that she received during the investigation.
Are you offering it for the truth of the matter asserted?
Yes.
Okay. Ms. Mayor, did you want to say something else? And the microphone isn't pointed towards you, so thanks.
The only other objection I would add is 403, as well as hearsay.
Okay. The objections are overruled.
And so some of the conflicting information you had was that,
Your Honor, could we approach the court?
Oh, sure. Feel free to stretch.
Okay, a sidebar there. the defense able to get out after, so the jury's seen these photos of these 2012 incidents, a boy with marks on his back, and it's, because the witness basically says he did it. This is prior abuse to another child. And now the defense has been able to get out this other narrative that there was a story that he may have fallen onto a toy box, and that's how he got those injuries. And during this divorce, she may have been lying about this for custody reasons, etc. We'll see how it plays out. Let's pick it up after the sidebar.
And this is just being offered for the credibility of this witness and the context of her previous statements. So I correct my previous assertion.
Okay. All right. So Ms. Parham isn't offering this information for the truth of the matter, what's asserted in the statement, just to help you in making determinations with regard to credibility and the context of the statement. Thanks. You can proceed.
And so going back to the 2012 incident, you had conflicting information about where these injuries came from, right?
Yes.
You had information that Sean got the injuries from falling on a toolbox.
Toy box, yes.
Toy box, sorry.
No,
yes. That he got the injuries from falling off a merry-go-round.
Yes.
And if I could have one moment.
Oh, sure. I'm sorry, couldn't
And
hear.
nothing further, sorry.
Nothing else. No worries. Ms. Mayor.
Well, just to follow up on that, Ms. Thrill-Kill, did you also have information that this was attributed to a hose?
Yes.
Did you have information that this was attributable to a sprinkler?
No, I don't remember a sprinkler. I just remember a hose.
Were you there?
No.
So I guess my question to you is this information that defense counsel's asking you about, this is just information you've heard from other people, correct?
Yes.
Do you know what happened?
No.
Did you ever tell a judge that you knew what happened?
No.
Back in 2012, when defense counsel is asking you about the custody proceeding, did you fight for custody of your children?
Yes.
Did you earn primary custody of your children?
Yes.
What custody was earned by the defendant?
I believe his parenting time was restricted. He had to...
Well, let me just ask you this.
Yeah, go ahead.
What amount of time was he granted?
4 days, I believe. A week.
Okay, and that was back when you both lived here?
Yes.
Okay. Do you agree, at some point, defendant moved to Paradise Valley Trailer Park 2, correct?
Yes.
I assume that was super helpful for arranging children when you live in the exact same area.
No.
Oh,
I mean, yes, but no, we had conflicts.
okay. Did things become harder once you moved away to Denver?
Yes.
Defense counsel asked you about statements that you made to Jackie Berry at DHS that you had kicked out Zach and ended the relationship. Did that ever happen?
We did for a while.
So that's what I guess I want to ask you a little bit about. Defense counsel asked you about a statement that was made to Jackie Berry July 7th, 2016 concerning kicking out Zach and ending the relationship. After Martin died, were your children placed with Natalie Freeman?
Yes.
Were there guardianship hearings pertaining to whether or not Natalie had earned guardianship of your children?
I believe that came after the 7th. Yes.
Right. That happened after the 7th.
Yes.
Did you go fight for custody of your kids?
Absolutely.
Did you want your kids to live with you?
Yes.
When defense counsel asked you about getting married to Zach, when did you believe this marriage was before 2016 or after 2016?
It was before. We had been together for 6 months, and I guess by technical law for Colorado, we were already common law.
And defense counsel asked you a question about having a baby with Zach. When was that baby born?
February 12th, 2021.
And guardianship would have been determined roughly sometime in 2016?
Yes.
So the baby that defense counsel asked you about was born, what would that be, 5 years later?
Somewhere in there, yes.
Okay. Thank you. I don't have any further questions.
Ms. Parham, other questions?
And that was it for the ex on the stand. She did move the needle, one could argue, because of this allegation of a prior potential child abuse case. And this defendant is on trial for the death of a 6-year-old in his care. Prosecutors say he lost his cool when the 6-year-old had little Martin had a bathroom accident, and that was too much. That's what the state's alleging. The defense says no, Martin had some physical issues, including pneumonia and asthma, and that's why he died. Trial attorney, former prosecutor Imran Ansari is with us. Overall thoughts on this case? Good to see you, by the way.
Yeah, I mean, it's... Oh, good to see you too, Ted. I haven't been on with you in a while. It's always a pleasure to be on. I mean, this case is a tragedy, right? Whenever you have a loss of life of someone so young, it's a tragedy. Now, here's the question for the jury. Was this an intentional murder or was this something health-related? And, you know, the testimony we just saw from the ex-wife, I think, is supportive for the prosecution. If the jury is going to take that information and find that testimony credible, that, you know, there was abuse for another child in another relationship, and that this could have been the same sort of situation with an abuse from the defendant to little Martin here. So defense did a good job, though, I think, in the sense of trying to get out some bias as to why she would have made that allegation against the defendant for her child, and, you know, the custody issues, and whether that was a real credible injury at the hands of the defendant or something else. So, you know, you saw the needle being moved, as you say, for the prosecution, I believe, a bit, but the defense did what they could with this witness in terms of maybe raising some question marks as to her credibility and a motive to make an allegation of abuse against the defendant for her child during their divorce and custody battle.
The overarching picture that was painted by this witness is little Martin was in an environment of chaos, and it just seemed like things weren't buttoned up. Does that help or hurt the defendant?
Yeah, no, I think that's something that could suggest the prosecution's theory that this defendant just couldn't take any more of these accidents, and that if that chaos in that home environment was such that, you know, the defendant was in a situation where he may have snapped, right? And he couldn't take the situation with these accidents occurring with Martin, and therefore the strangulation occurred. So that chaotic environment, I think, feeds into this narrative from the prosecution that it was abusive. It was abuse at the hands of this defendant. And then, unfortunately, you have Martin as a victim of that abuse as alleged against this defendant.
Mm-hmm. Yeah, I agree. This is it's just a horrible case. By any measure, a little boy lost his life, and I think you could argue that his life was in an environment that had a lot of moving parts and was just not stable. Let's get a break. When we come back, more testimony in the father figure murder trial. Former child intake worker testifies next.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge watching Bull. Sundays on Court TV.
back to Court TV Live. We're tracking a couple cases around the country this morning. In Florida, the adoptive son murder trial for Dima Tower continues in about an hour, 45 minutes from now. He's accused of brutally murdering his parents, Jennifer and Robbie Tower. Again, 11 o'clock, the jury is reporting to that Florida courtroom. In Nevada, the love triangle beheading trial for former porn star Devin Michaels resumes. We'll talk more about that in this case later this hour. And in Colorado, the state's case continues in the father figure murder trial for Darren Thrailkill. He's accused of killing his girlfriend's 6-year-old son, Martin. While we're waiting for testimony to resume in Colorado, we're going back and listening to key testimony from yesterday. A former child intake worker is talking about previous incidents with Thrailkill's children.
The purpose of your interview with Sean that day, you testified it was for you to investigate an allegation of child abuse. What did you do when you first got there? I mean, you testified that Sean was 4 at the time. What did you do to make sure that Sean was comfortable talking to you and you were comfortable talking to Sean?
You build rapport with kiddos. In this case, with Sean, given that he had 2 different homes, I used some of the training that I had. I brought out a picture of a home and I said, who lives at Dad's home? And he listed out all the people that live there. What happens when he gets in trouble. And then he told me about being hit with a water hose with a sprinkler on the end of it, and him getting wet. When I asked for him to maybe show me how it happened, he kind of shut down and curled up in the fetal position, and just kind of looked at me like, and at that time I backed off that topic. And so we decided to talk about Mom's house. And so we filled out a house for Mom and who lives there. And we talked about his friends in the trailer park, what happens when he gets in trouble at Mom's house. And then we went back to the hose, and he repeated at least 4 times that Daddy did it. He was very consistent. I believe it around that time, Mom came back in the kitchen. I interviewed him alone. It was just him and his sister.
And I'd object now to this being narrative.
Mr. Zentner?
Thank you, Judge. I can ask a couple more questions here based on the responses provided so far by Ms. Yates.
Okay, thank you.
Ms. Yates, you testified earlier that you build rapport with Sean. You asked him to make some drawings with you. During the time that you spent with him, and you asked him to draw some things like the 2 homes he was in, Dad's home, Mom's home. Were you alone with him?
Yes.
And you testified earlier that after that, you did that because was Sean hesitant initially to talk to you?
He was wary. Yeah.
Was that abnormal for a 4-year-old, almost 5-year-old to be kind of wary or hesitant to talk to you?
I would expect for him to be hesitant to talk to me.
And is that why you engaged with him and tried to engage with him and make him comfortable?
Yeah, you get down and bring out pictures and have a conversation.
After you got down with him and had him draw those pictures, you stated that Sean said something to you about being hit with a water sprinkler. What was or a hose or a sprinkler? What was your memory of how that came up? Did you ask him about that? Did you lead him into that? How did that come up?
We were talking about discipline. What happens when you get in trouble. So
What you said earlier about Sean saying something about being hit with a sprinkler, was that just kind of uninvited that he said that?
From what I remember, he knew that I was there to talk about what happened to his back, but did I ask him straight out? No.
And why wouldn't you have asked him straight out? Is that something you try to avoid?
Yes, especially with 4-year-olds. Sometimes they'll, pick up on something they think you want to hear, and then that's what they'll go with.
You had testified earlier that he had repeated 4 times that Daddy did it. At this point, after Sean had brought up the fact that he had been hit with a sprinkler hose, sprinkler or hose, is that when you would ask him, did you ask him kind of 4 separate ways just to make sure what he said that Daddy did it? Or why did he repeat 4 times that Daddy did it?
I do not remember. It's been almost 14 years. I just can tell you what I documented.
Your testimony today was that he had repeated 4 times that Daddy did it. Did he shut down after he had said this?
Yes.
Okay. What did you do when he shut down?
I re-engaged him by, let's draw a picture of your mom's house.
And then did he come back to the conversation after you had re-engaged him and asked him to draw a picture of his mom's house?
Yes.
What else did he tell you? What else did you discuss with 4-year-old Sean Thrill Kill at that point? Did you ask him again about his back?
We went back to it after we talked about who lives at mom's house and who his friends are.
And at that point, did he indicate to you again who had caused that injury?
He said his dad.
And were his exact words, Daddy did it?
Yes.
Did you also ask him in that conversation and establish with him whether or not he wanted to go back to his dad's house?
He did not.
He told you he did not want to go back to his dad's house?
Yes.
All right. One moment, please. Regarding your conversation with Sean, did you see the injury? Did you ask to see the injury?
I did when mom joined us, yes.
Describe to the jury what you saw. I mean, you testified today that in preparation for today, you do recall this case. Do you remember this case for any other reason based on your observation of the injuries?
I remember it. I just remember the yellow bruise that went on his lower back and wrapped around his hip. And it had been 9 days since he had come back from Dad's house, and it was still visible.
Were you concerned about the level of bruising based on the time frames involved here, based on what you knew?
Yes.
The emotion you're showing now, is that something that when you think of what you saw and the amount of bruising, is that something that brings back memories for you?
It does, yeah.
No further questions at this time, Judge.
Ms. Parham, cross-examination.
Wow, home run there by the prosecution. They were able to say, Daddy did it 1,000 times, and then you get the professional who deals with kids all the time to break down and get emotional thinking about the bruise, throwing in after returning from Dad's house. I don't know how you recover from that, but we'll find out what the defense does on the cross-examination when we return. Plus, we're going to check in with our Matt Johnson on this trial out of Vegas. The former porn star Devin Michaels accused of beheading her boyfriend.
Maker.
Hey everyone, it's me, Devin Michaels. Come say hi. Anything unique about the body?
I think initially, obviously, that it was decapitated.
For you to be able to look me in the eye knowing that the things are altered and...
You pled guilty, man. If he had known you were having a sexual relationship with his mother of his children.
I'm not going to stop fighting to prove my innocence.
We'll head back to court in Florida in a moment, but right now we want to update you on that trial. Vegas, the love triangle beheading trial for Devin Michaels. The state's case resumes later today, 2 o'clock Eastern time. Joining us now in studio with all the latest on this one is Court TV crime and justice correspondent Matt Johnson. All right, where are we in the trial? Get us up to speed.
Fast-moving trial, a lot of twists and turns there out of Sin City, Las Vegas, Nevada. Today is day 6, folks, and we can expect more bombshell testimony. Devin Michaels is the former porn star accused of bludgeoning and beheading her ex-boyfriend, Jonathan Willett, in a love triangle. Remember, he's the father of her 2 kids. She was also married to the victim's son from a previous marriage. Her defense pointing the finger at that guy, saying that he's the real killer. Well, on Wednesday yesterday, the lead detective in the case took the stand describing the brutal murder scene. Take a listen.
You can see the bed, you can see the blankets. You can't see him yet, and you don't see him or his body until you get closer to the front of the bed, and then you start to wrap around. Then at that point, you can start seeing the blood on the bed, blood stains, and then blood next to the bed at that point. And then when we get closer, or at least when I got closer, you could have that chemical smell that started burning your nose and your eyes at that time. We also noticed that there wasn't any blood spatter on the walls or on the ceiling. Just given the type of injury that we were seeing, you expect to probably see a little bit more blood in other places. And then just through that quick brief walkthrough, I didn't see any weapons or any devices that were believed to be used that would have severed his head off at that time.
His head was never found. This is a very disturbing case playing out in that Las Vegas courtroom. The day ended with a DNA analyst on the stand confirming that the defendant's DNA was on victims' items recovered inside of a plastic bag, including the victim's only set of truck keys and his wallet. Once again, another piece of evidence in the state's case in chief linking her to the crime.
What are we watching for today as we move through here? Should be getting close to the end of the state's case in chief.
Yeah, they're rapidly approaching the state's end of their case in chief. Testimony resumes at 2 o'clock Eastern today. We're approaching the end of the state's case, and then we'll know the answer to the big question in all of this. Will this former porn star take the stand? Well, again, in opening statements and cross-examination of witnesses, the defense has been pointing the finger at the victim's son, who is also the defendant's husband. Plus, the defendant made this statement in open court when she was supposed to be sentenced during a plea deal. Take a listen.
I know right now no one in the family feels that I'm innocent at any point, and I understand that, but I can actually prove my innocence. I actually can, and I'm not going to stop fighting to prove my innocence.
Clearly, that plea deal was withdrawn. Now we're in trial. This is, again, day 6. And, you know, there has also been another big factor in this case. You recognize the defense team, Robert Draskovich, Michael Horvath. This team is spot on. They have really been fighting from the beginning. And we know them from the Robert Tellez trial that I covered in Las Vegas. So we can expect a big defense that they're putting together. You know, in this trial that we're covering right now, as we're leading up to the 2 o'clock, they keep on saying, Daddy did it. In this case, we're going to hear over and over again, the son did it.
Yes, and we already have. And this defense team is not opposed to putting on a bit of an unhinged person on the stand. We saw that with Tellez.
Yeah, you know, they did put him on the stand.
Didn't work out.
It didn't really work out, and it was, they weren't asking him questions. He was just giving a narrative. But in this case, again, she said in open court, she made that whole big speech. So we might be looking at someone who is obsessed with social media in a prior life and being on camera in different ways. But she may want to take center stage in her own murder trial and tell her story, whatever that looks like.
Yeah, I mean, that's the question. What does that look like? Because there is evidence against her. Matt Johnson, thank you. Imran Ansari, what do you think of this wild case out in Vegas? Just so many details. The fact that she's married to the decedent's son, and they're blaming the son for the murder, and then the whole plea gone awry. Your take?
Yeah, I mean, there's a lot of moving parts and a lot of interesting moving parts, to say the least. And I think Giordani, who's the prosecutor, said to the jury leading into this trial, you know, buckle in, you're in for a wild ride. And I think that wild ride has already started. And if you want to look back, you know, you saw that camera footage, that clip from her sentencing where she professes her innocence, and this then now is sent to trial with that plea withdrawn. I mean, it's setting the stage for quite a trial, and we see that happening right now. And then you have the moving parts and the sort of crossing love affairs between the father and then marrying the son, and then the father ending up tragically and horrifically and brutally murdered. I mean, it's really has all the makings for a really interesting trial with a plot line and narrative leading up to this trial. I think she's going to take the stand. You saw her give that colloquy to you know, the court when she was professing her innocence at sentencing, and it you know, my gut instinct is that this is a defendant who wants to testify, and even if her counsel is saying, all right, maybe it's not the right move, she is going to want to speak to that jury, and I think we're going to see her on the stand.
To what extent, if she chooses to take the stand, does the prior plea agreement, which was all in place right before that plea hearing that went awry, how much of that comes in detail in terms of the jury? Will the prosecution be able to say, isn't it true, you were going to plead guilty to this crime?
Yeah, it really shouldn't. You know, if there was a ruling by the judge, you know, on this already, or we have to see how it's going to be proffered as potential evidence during the testimony, if she takes the stand, that is. But it really shouldn't, because you don't want that jury in any way factoring in that she pled guilty at one point and then withdrew it, and that was a legal event, right? That was pursuant to the law. She was permitted ultimately to withdraw that guilty plea and take her case to trial. So you don't want the jury to know about that, because that would certainly prejudice the defendant, taint the jury in terms of their analysis and their appreciation of the evidence alone at trial. So I think we're going to have that precluded from reaching the jury's ears.
Yeah, it'll be fascinating. We'll see if she does take the stand when it is her time to make that decision. They'll be back at it at 11 o'clock Pacific time, 2 o'clock Eastern time, and we'll be watching. We'll get a break. When we come back, we'll head back to Colorado. More of the father figure murder trial. We'll listen to the cross-examination. This child intake worker who interviewed and broke down on the stand after interviewing Thrail-Kill's son after an alleged abuse to him. We'll watch the cross. Plus, testimony set to resume soon in the adopted son murder trial for Dima Tower. There's a live look inside that Florida courtroom. Busy Thursday. Stay with us.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
All right, help party, I'm dying.
Don't you have the blood of both these men on your hands?
I feel guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Court TV Live. Court resumes in the father figure murder trial later this morning for defendant Darren Thrail kill. He's accused of killing his son. Well, not his son, his girlfriend's son. 6-year-old little boy named Martin. State says Thrail kill lost it. Hit his breaking point after little Martin had a bathroom accident. The defense says no, it's a combination of pneumonia and asthma. That's what caused Martin's death. Right now, we're listening to a key witness in the state. It's a Child Protective Services intake worker. She interviewed Thrail Kill's other son, trying to get to the bottom of some alleged abuse. She broke down on the stand and was able to, basically, the prosecutor was able to tell the jury about 1,000 times, Daddy did it. That's what the son told this worker. Let's see how the defense does on cross.
And so when you responded on April 4th, 2012, the information you had when you responded was that there were bruises and that there were multiple accounts about what happened, right?
I think that was a referral.
Okay. Specifically that he had given 3 different stories on how it happened.
I don't remember the referral. If that's what was on there, that's what was on there.
Okay. And you testified about this water sprinkler. And so you don't have independent memories of this conversation, right?
No, I have what I wrote.
Okay. And so when you wrote your report, you indicated that Sean, stated something about being hit with a water sprinkler, and he stated he was hit by a water hose and hit by the sprinkler, right?
If that's what it says.
Okay. He never told you that Mr. Thrailkill hit him with the sprinkler.
Did he? He didn't. No, he didn't say Dad hit me with the sprinkler.
Okay. And you testified on direct that when Mr. Sentner asked, did he indicate again who caused the injury? And you stated he said his dad. He did not tell you specifically how he got the bruises. He wouldn't elaborate on that.
No.
Okay. And he didn't say specifically that the bruises were caused by being hit by a sprinkler.
He's 4.
Okay. And so he did not say that though, correct?
No 4-year-old would. No.
Okay, thank you. And at the time that you talked to them, the parents have been separated for just a few months, right?
I think I remember that.
There was a custody situation going on.
I don't know if the custody stuff was going on before or was initiated by this. I can't remember.
Okay, but it was going on at the time. And there were a few days in between the report and you responding.
Yes,
right?
I had to wait on law enforcement.
Okay. And you don't know what happened in those days in between, right?
I don't.
You know that Sean was living with his mom.
Yes.
You indicated that he knew you were there to talk to him about his back, right?
Yes.
And you didn't tell him that.
Yes, I did.
You said you wouldn't have asked him straight out about his back because you didn't want to lead, right?
I'm trying to remember. I honestly don't remember.
Okay, you just testified on direct that you wouldn't have asked him that straight out.
I wouldn't have.
Okay. But he knew that that was why you were there.
Yes, but I can't tell you that he didn't overhear a conversation with the detective and his mom.
Okay. But you know he was living with his mom during that time.
He was at her house at the time.
You don't know what his mom might have told him about what happened pertaining to the bruise. You don't know what his mom might have told him about his dad, his new relationship.
No.
He did make statements though during your conversation with him. He labeled Crystal and Martin as bad.
He did.
And he also indicated that Miss Osinski would, quote, get dad into trouble.
Is that Crystal's last name?
Yes.
Okay.
Does that sound right, though?
Yes.
Okay. And you did note in your report that the parents appeared, or the divorce seemed to be having a poor effect on the children.
Yeah, it was contentious.
Okay. That Sean appeared to have some anger issues and acting out behavior surrounding the divorce.
I think that was reported to me, yes.
Okay. I have nothing.
Okay. Other questions for the witness, Mr. Zentner?
One moment, Judge.
Here.
So I think one of my questions to you earlier might have been a little inartful or confusing, but to be clear, what Sean had told you remained consistent. The statements that Ms. Parham had asked you about came from other sources. Is that right?
Which statements? The one
about, so Sean's statements about being hit and who hit him, those remain consistent. Would you agree with that?
he said Daddy did it consistently.
Okay. And then Ms. Parham had asked about some things that you wrote in your report. And I just want to be clear with you. If I could, the record will reflect I'm approaching with discovery page 2831. I've provided this to Ms. Parham.
No, thank you.
I provided you with discovery page 2831. You've provided testimony that you had written, you had referred to your report. When you went to Ms. Threlkill's home and interviewed Sean, did you write a report?
I did.
And when you're writing the report, are you writing it on a tablet or a laptop, and are you trying to take notes contemporaneously with your interview?
When I'm doing the child's interview, I'm just with him. It was my practice when we bring them, the parent in to type that up and then finish it up after I leave.
So when you were meeting with Sean Threlkill alone, you would have been typing contemporaneously with your interview of him?
No, I was paying attention to him. Yeah.
Did you then, after you met with Sean Threlkill and then had his mom come back in, did you write a report that day, though, while it was fresh in,
Yes.
in your mind as to what Sean had told you?
Yes.
And is that the report that you wrote?
Yes.
I had asked you earlier, and it seemed like there were two separate times where Sean had told you about Daddy doing it, and then he would shut down, and then you went back again. Have you just review your report briefly, and then I'll have a question for
You guys could make it bigger.
Can you read that, or is that a little too small?
I just give me a second. Okay. He shut down initially.
All right, she's having a tough time reading that, but boy, that prosecution team on direct had either her say it or they said Daddy did it a ton of times, and now here we are on direct, going right back to the well, making sure the jury knows that this young man said that Daddy did it in terms of his injuries. Let's get a break. We're gearing up for testimony to resume in the adopted son murder trial for Dima Tower in Florida. That's next. Stay with us.
be seated. Bring Mr. Tower.
Please come. Seriously, transfer the property.
I'm cold inside. I don't know if you knew that. You thought it was warm? All the jurors up? All right, welcome back, everybody. We have the defendant, Mr. Tower, prosecutors, defense attorney. Are both sides ready to proceed?
Yes, we are.
Yes, Your Honor. And I think we have the state, your FDLE expert. After this witness, we're going to adjourn for lunch. We'll come back afterwards with Dr. Vega. Is that right?
That's right, Your Honor.
Okay. All right, let's bring the jurors in.
Yes, Sean. All rise. Jurors enter.
All right, everybody may be seated. Welcome back, members of the jury. I hope you had a nice evening. The witness arrived, so we're ready to proceed. All right, State, please call your next witness.
State calls Charlene Webster.
All right, everybody stand right here, face the clerk, raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, well, you can bring right in up that right.
Morning. State when you're ready, you may proceed.
Thank you. Hello, Ms. Webster.
Hello.
Will you please tell us your full name and spell your last name?
Yes, my name is Charlene Webster. Last name is spelled W-E-B-S-T-E-R.
How are you employed, Ms. Webster?
I am a senior crime laboratory analyst with the Florida Department of Law Enforcement at the Tampa Bay Regional Operations Center in the biology section.
How long have you worked for the Florida Department of Law Enforcement?
Since December of 2009.
Will you tell the members of the jury about your formal education, please?
I have a Bachelor of Arts in Anthropology and a Bachelor of Science in Biochemistry from the University of Miami. I also hold a Master of Science in Pharmacy with a concentration in Forensic DNA and Serology from the University of Florida.
Thank you. Will you also tell us a little bit about the duties and responsibilities of a senior crime lab analyst?
Yes, as an analyst, I examine items of evidence for the presence of body fluids such as blood, semen, or saliva. I also examine them for any skin cells that may be present from items that may have been handled, touched, or worn. I will take samplings of those items of evidence to try to develop a DNA profile that I can then compare to the DNA profiles of known individuals that are believed to be involved in the case. I will put a statistical weight if I'm able to do that and produce a report.
What is DNA?
DNA stands for deoxyribonucleic acid. It is the genetic blueprint for life, and it makes us who we are. Your DNA profile is unique, except in the case of identical twins. You inherit half of your DNA from your biological mother and the other half from your biological father. Your DNA is found all throughout your body, so except for mature red blood cells, and your DNA doesn't change over your life. So the DNA I would find in your hair would be the same DNA I would expect to find in your blood.
What method of DNA analysis do you use up at the Florida Department of Law Enforcement's office in Tampa?
We use STR testing, which stands for short tandem repeats. And STRs are just small segments that are found throughout the DNA. The number of times those repeating segments are observed varies from individuals. And as I mentioned earlier, since you get half from your mother and half from your father, the number of repeats you get from each person would vary. That process is done in 4 steps. So what I'm going to try to do in the first step is I'm going to take that sample of the evidence and I'm going to place it in a tube. I'm going to add some liquid and some heat, and the purpose of that is just to try to break open those cells so they can release the DNA so I can see what's available to me. The second step is then now to make many copies of the 21 locations on the DNA strand that I'm actually looking at. And I'm trying to make those copies so that way I can get a better idea of the DNA profile. The third step is now, the second step I misspoke was determining how much DNA I actually have present. Once I open up those cells, how much DNA is available to me. The third step is making millions of copies of the 21 locations on the DNA strand that I'm looking at. And then the last step is just separating those copied DNA by size, so that way I end up with peaks on a graph, much like an EKG, and those peaks are your DNA profile for each of the 21 areas of the DNA I'm looking at.
That method that you just described, short tandem repeat, is that supported in the scientific community?
Yes, it is.
By published scientific literature?
Yes.
Okay. Now, your lab in Tampa, is it accredited?
Yes, we are.
With whom is it accredited?
We are accredited by ANAB, which is the American National Standards Institute National Accreditation Board.
And as an individual crime laboratory analyst, do you have some sort of continuing education or accreditation that you have to do personally?
Yes, I do have to do 16 hours of continuing education each calendar year. In addition, I do have to take what's called a proficiency test twice a year. A proficiency test is just a scenario-based test that's given to me from an outside agency. I know I'm being tested, but I don't know the results of the test. Once I receive the samples, I will take the samples from start to finish, just as I would any other case working sample using our standard operating procedures. Once I get my results, I submit it to the testing agency, who then ensures that my results are consistent with theirs, and they will report that back to ANAB, our accrediting body, and to FDLE as well.
When was the last proficiency test that you undertook?
Earlier this year, and I passed it.
Okay, that's what I wanted to know. How do you talked about your protocols. How do you ensure that the results that you achieve in your laboratory are correct? How do you know that you're getting the correct results? What steps do you take?
We have controls that are run with all of our samples. So as I mentioned earlier, as a part of that STR process, that I took a sample of the item of evidence to do through the 4 steps. Well, I'm also going to do that with what's called a reagent blank. So it's just an empty tube, and everything that happens to my sample happens to that tube through all 4 steps of the STR process. That's called a negative control, and that just ensures that no outside DNA is being introduced into the samples. In addition, there's also a positive control that's run through the samples to just ensure that all of the reagents are performing and the instruments are performing the way that they should and producing the expected results that is received from that positive control.
Right. As an analyst, do you maintain neutrality when you are working with items that have been submitted to you by various agencies and throughout the testing process?
Yes.
Why is it important for you to maintain a neutral attitude about the evidence that comes into you for testing?
When I receive the evidence, I don't know what to expect as a result, so I'm just going to conduct my testing as I would with every other item that's similar. I'm going to send it through the same process, of course, not to be biased in any way, just to perform it and to try to get any DNA profiles that may be usable in the case.
Thank you. Now, you mentioned a little bit earlier about statistical analysis is used as part of the procedure for ultimate DNA analysis. Do you have specialized training in statistics?
Yes.
Can you tell us a little bit about the training that you've received in statistics?
So I took statistics as a part of my master's class. In addition to during the training program at FDLE, we are trained on the statistics that we perform, which is currently likelihood ratio. In addition to the training that I received from FDLE, the members of the program that we use also did a 2-week statistical training class on the system, and so I did get that training as well.
Does the Florida Department of Law Enforcement use a particular database as part of your statistical analysis?
Yes, we do.
Can you explain a little bit about that database, please?
The database we use is developed from, the National Institutes of Standard and Technology. That database was published in the Forensic Science International Journal of Forensics in 2013. And basically that database contains DNA profiles from random people who were samples that were purchased, and the DNA types that were observed there are just telling me how common or how rare a particular allele or DNA type may be observed in the general population across 3 ethnicities. The ethnicities we look at are Caucasian, Hispanic, and African American, as those are the 3 common ethnicities found in the state of Florida.
Okay. Why do you use a numerical weight or a statistical weight as part of the DNA analysis?
We add a statistical weight to a sample that is a match, which means that I compared a single source or profile from one individual to a known individual, or an inclusion where I'm comparing an individual to what's called a mixture, where that's from 2 or more individuals. It gives a statistical weight as to how common or how rare, given the DNA evidence, how likely it is to see that DNA evidence how likely it is to see that that DNA evidence given the profile that is observed let me rephrase that. The statistical weight gives I'm looking at the DNA profile and I'm comparing a known individual to the profile, either to a single source or a mixture. It just gives weight as to how common or how rare that DNA profile may be observed. Sorry.
Okay. Essentially, does that allow you to put into perspective the results as to how much of that person's DNA is in that particular sample?
It's actually just saying it's comparing two different scenarios and giving a weight. It's comparing how likely that DNA profile could be from the person of interest or an unknown individual. So it's not telling me that that person is actually in the profile. It's just telling me what is the likelihood that the evidence could be from the person of interest versus an unknown individual.
All right, thank you. Now, have you ever testified in court with regard to DNA analysis?
Yes.
How many times, approximately, Ms. Webster?
Probably about 50-ish.
Okay. And can you give us an idea of where in the state of Florida you've given testimony on DNA?
I've gone as high as Tallahassee, and I've gone as further south as Fort Myers, where we have our different regions. So any of the courthouses in between there, I've probably touched on a few of them.
All right, great. Now, I want to ask you about how, as an FDLE analyst, how do you determine or examine an item of evidence to know if there is blood on that item? Can you explain that process to us?
Yes, if I'm examining an item of evidence, I'm going to look at it to see if it has red-brown staining that may be possibly present, as that's somewhat characteristics of what a blood stain would look like. If I observe red-brown staining on the item, I'm going to perform what's called a presumptive test, which is just a chemical change test that tells me whether or not blood is probably present, but what it possibly isn't. I cannot confirm that it is blood, but I can say that blood is possibly present. That color change test takes a clear liquid, and it turns pink if blood is possibly present.
Okay. Did you receive known samples in this particular case of the defendant Dima Tower and also Jennifer and Robbie Tower?
Yes, I did.
In what forms did you receive those known samples, Ms. Webster?
I received a buccal swab from Dima Tower, and I received a blood stain card from Robbie Tower and a blood stain card from Jennifer Tower.
Okay. Now, as to the buccal swab from Dima Tower, did you obtain a complete DNA profile for Dima Tower?
Yes, I did.
And as to the blood stain cards, did you obtain complete DNA profiles for both Jennifer Tower and Robbie Tower?
Yes, I did.
Okay, so did you also receive items of evidence, or did your lab receive items of evidence from the Northport Police Department?
Yes, we did.
Can you please tell the members of the jury, and without going through the entire list, if you could just tell us about items 6.1 and 7.8.
May I refer to my notes?
You may, if it would help to refresh your recollection.
Item 6.1 is described as a DNA sample that was taken from the knife blade.
Okay, and 6.1, was that derived from a kitchen knife? And
Yes.
Thank you. And then as to item 7.8, can you tell us what that item of evidence is?
Item 7.8 is described as a DNA sample from knife 6's handle.
Okay, thank you. All right. So speaking specifically of those two items, 6.1, the knife blade, and 7.8, the knife handle, and those are from two distinct knives.
That's
Am I
correct.
Thank you. Okay. Did FDLE test those items?
Yes, we did.
Okay. Can you please explain the initial results of that test?
Item 6 is the kitchen knife did give chemical indications for the presence of blood. That means I did that presumptive color change test that I described earlier, there was a color change for pink. So the results that it gave chemical indications for blood.
All right, and what about 7.8? Just as to the blood, the serology.
That's right. Yes. So there was, I also did obtain, there was chemical indications for the presence of blood on item 7.8 as well.
Thank you. Now let's go back to 6.1. Once you found the chemical indications for the presence of blood on that knife blade, what was the next step in the analysis?
After that, I would have taken, there was a sampling taken of the knife handle and the blade, and then the samples would have been placed in a tube that I described earlier and taken through that 4-step process as I described it in order to try to develop a DNA profile for each of those items.
Okay. And what were the DNA results that you obtained from the knife blade, item 6.1?
So for item 6.1, the knife blade, the DNA results obtained demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor.
Okay, and were you able to determine of any of those donors in that particular item, 6.1, the knife blade?
I was able to include Dima Tower as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is approximately 61,000 times more likely to occur if the sample originated from Dima Tower and 1 unrelated individual than if it originated from 2 unrelated individuals.
Okay, were you also given an indication of one of the other donors in that mixture?
I was able to include Robbie Tower as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Robbie Tower and 1 unrelated individual than from 2 unrelated individuals.
Okay, so if we can break that down just into layperson's language, can you just simplify that for the members of the jury?
As I mentioned in the statistic, it's giving away, the type of statistic I'm giving you is called a likelihood ratio, and it's comparing 2 opposing hypotheses. So it's comparing whether or not the person of interest could be given the DNA profile, the person of interest could be the donor of the profile versus if an unknown individual could be the donor of the evidence profile observed. In this case, I'm giving weight to whether or not, for the evidence, if Dima Tower is included, the likelihood for the DNA profile is approximately 67,000 times more likely to occur if it originated from him versus non-related individual. I'm giving weight more to each of those scenarios, and it's on a sliding scale. So if a likelihood ratio of 1 just means that it's neutral. It doesn't give weight to either one of those scenarios. As you get higher above 1, the number 1, it gives weight more to my first scenario of the person of interest being the possible donor of that DNA profile. As it gets lower from 1, it's stating that it's supporting more of that second hypothesis, or that an unknown individual is the one that donated that DNA profile.
Thank you. Now let's move on to the knife handle from 7.8, the other knife, the second knife. Can you please tell us about the results after you did your analysis, Ms. Webster?
The DNA results for item 7.8 demonstrated the presence of a mixture of at least 2 donors, including at least 1 male contributor. A complete DNA profile for the major contributor could be determined and is suitable for comparisons. Due to the limited nature of the DNA results for this additional contributors to the mixture, that data wasn't interpretable. So I'm only making comparisons to the major DNA profile. This major DNA profile matched the DNA profile from Robbie Tower. The observed major DNA profile is greater than 700 billion times more likely to occur if the sample originated from Robbie Tower than from an unrelated individual.
Thank you. Now, I just want to ask you a question regarding this particular evidence. So these knives were in a kitchen, and presumably they were used by all the members of the family at any given time. The family members being Robbie Tower, Jennifer Tower, and Dima Tower. So what distinguishes the DNA that you found on these two knives? What's the distinction? Is it because you found chemical indications for the presence of blood as opposed to touch DNA?
Objection leading? Yeah, let's try not to be
All
so
right.
leading in your question.
Thank you.
Do
So-
you understand the question as a general concept? Can you explain touch DNA versus blood DNA? Okay, I think that's the question.
Please.
Yes, so if blood DNA from blood, blood is as a body fluid in general would produce more DNA or leave more DNA behind than just touching an item. However, I can't say in this case as to which one those came from, as the knives may have been handled as stated by everyone throughout the family. I can't state whether or not the DNA is exclusively from blood or from epithelial cells.
Thank you. But based upon your analysis, were there chemical indications for the presence of blood on both knives?
Yes, there was.
Thank you. May I have a moment, please?
Amen.
Thank you very much. I don't have anything else.
Mr. Gilman, when you're ready.
Good morning, ma'am. How are you?
Good morning, and well yourself.
All right. So when you're examining these items of evidence, you examine essentially what's submitted, right?
Correct.
You don't go to the individual law enforcement headquarters and pick and choose what they give to you.
That is correct.
All right. So if they give you, for example, an actual physical knife, you would go through and do all of the swabbing yourself, correct?
Correct.
If they don't give you the physical knife, they just give you whatever the swabs are, you test from the swabs, correct?
Correct.
So you're entirely at the discretion of what is submitted to you as far as what gets tested.
Correct.
All right. And that system is automated, correct?
What do you mean by automated?
I mean, you don't go in and with like a pair of tweezers and pull out DNA, right?
No, I don't use a tweezer to go in. I do the process that we described.
Right, it's automated through machinery, right?
Yes, there are some hands-on portions, but yes, there are some machinery that helps with that.
And the peaks and valleys are essentially computer-generated results, correct?
Correct.
All right. The statistical analysis that you do has changed since you started in 2009, hasn't it?
Yes, it has.
Okay. And it used to be that you would give numbers like 1 in 15 and make like sounding like really horrible made up numbers for a statistical analysis, correct? And you'd have to count the number of zeros to describe the number?
Yes, we still do that. There's still big numbers now.
Okay. But it sounds to me like you said that the 2 times that you discovered Robbie Tower's DNA, that statistical likelihood was 700 billion times more likely, correct?
I stated that it's greater than 700 billion times more likely.
Okay. And then for the one instance where you indicated that you found Dima Tower in a mixture, it was 67,000, correct?
Approximately 61,000.
Okay. I think you said both 61 and 67, so it's 61?
It's 61,000.
Okay. And that's obviously closer to zero than 700 billion, right?
Yes.
Okay. And again, we're talking about a mixture, correct?
Yes, for
All right.
both samples.
And using the statistical analysis the way that you do, if you were to use a separate database than the one that you use, would you expect similar or different results?
Objection calls for speculation.
Would you be speculating, or do you know the answer to that?
I generally know the answer to that.
All right, I'll overrule the objection. You can answer it.
It would be slightly different, but I wouldn't expect there to be more than a tenfold difference.
Right, so back when you're talking about the big, huge numbers, if we're talking 700 billion, the tenfold difference would be 70 billion, correct?
Yes.
Okay. Nothing further, Judge.
State any redirect of the witness.
Did you find blood on those two knives?
Yes, I did find the indications for blood, yes.
Okay. And in addition, did you also find DNA from Robbie Tower and Dima Tower?
I was able to include Robbie Tower and Dima Tower on item 6.1.
And is that the bottom line of your report? In the most simplistic reductionist terms, is that the bottom line of your report?
Those are the results of my reporting, yes.
Thank you very much.
Is the witness free to step down?
Yes.
No objection.
All right, you may step down now. Thank you.
Okay, thank you.
Folks, as you recall, when we talked about scheduling, this is the witness this morning. The next witness is not available till 1 o'clock. So let's see, it's 11:51. Is an hour enough for you folks for lunch? I see the jurors say that's fine. Does that work for the parties?
It does, Your Honor.
Yes, Your Honor.
Let's start back up.
Dr. Vega is 1:15. Let's make it 1:15. Sorry.
1:15, okay? We'll see everybody at 1:15, okay? Please leave your notepads turned over, face down, writing implements on top. Have a nice lunch. Remember, do not discuss anything with each other, and don't observe, read,
Hey, welcome back to Court TV Live. I'm Kelly Craft. We are in Florida this afternoon for the adopted son murder trial. Jennifer and Robbie Tower adopted Dima Tower when he was 14 years old from a Ukrainian foster care. But soon, their new son would start to exhibit violent tendencies. And just 7 years later, Jennifer and Robbie Tower would be found dead. Prosecutors say that Dima went into his parents' bedroom on the night of August 31st, 2023, just days before his 22nd birthday, and began brutally stabbing them before fleeing the scene. Let's get you back into the courtroom now. We are hearing from a senior crime lab analyst.
Through that four-step process, as I described it, in order to try to develop a DNA profile for each of those items.
Okay. And what were the DNA results that you obtained from the knife blade, item 6.1?
So for item 6.1, the knife blade, the DNA results obtained demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor.
Okay, and were you able to determine of any of those donors in that particular item, 6.1, the knife blade?
I was able to include Dima Tower as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is approximately 61,000 times more likely to occur if the sample originated from Dima Tower and 1 unrelated individual than if it originated from 2 unrelated individuals.
Okay, were you also given an indication of one of the other donors in that mixture?
I was able to include Robbie Tower as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Robbie Tower and 1 unrelated individual than from 2 unrelated individuals.
Okay, so if we can break that down just into layperson's language, can you just simplify that for the members of the jury?
As I mentioned in the statistic, I just giving away, the type of statistic I'm giving you is called a likelihood ratio, and it's comparing 2 opposing hypotheses. So it's comparing whether or not the person of interest could be given the DNA profile, the person of interest could be the donor of the profile versus if an unknown individual could be the donor of the evidence profile observed. In this case, I'm giving weight to whether or not, for the evidence, if Dima Tower is included, the likelihood for the DNA profile is approximately 67,000 times more likely to occur if it originated from him versus non-related individual. I'm giving weight more to each of those scenarios, and it's on a sliding scale. So if a likelihood ratio of 1 just means that it's neutral. It doesn't give weight to either one of those scenarios. As you get higher above 1, the number 1, it gives weight more to my first scenario of the person of interest being the possible donor of that DNA profile. As it gets lower from 1, it's stating that it's supporting more of that second hypothesis, or that an unknown individual is the one that donated that DNA profile.
Thank you. Now let's move on to the knife handle from 7.8, the other knife, the second knife. Can you please tell us about the results after you did your analysis, Ms. Webster?
The DNA results for item 7.8 demonstrated the presence of a mixture of at least 2 donors, including at least 1 male contributor. A complete DNA profile for the major contributor could be determined and is suitable for comparisons. Due to the limited nature of the DNA results for the additional contributors to the mixture, that data wasn't interpretable. So I'm only making comparisons to the major DNA profile. This major DNA profile matched the DNA profile from Robbie Tower. The observed major DNA profile is greater than 700 billion times more likely to occur if the sample originated from Robbie Tower than from an unrelated individual.
Thank you. Now, I just want to ask you a question regarding this particular evidence. So these knives were in a kitchen, and presumably they were used by all the members of the family at any given time. The family members being Robbie Tower, Jennifer Tower, and Dima Tower. So what distinguishes the DNA that you found on these two knives? What's the distinction? Is it because you found chemical indications for the presence of blood as opposed to touch DNA?
Objection leading? Yeah, let's try not to be
All
so
right.
leading in your question.
Thank you.
Do
So-
you understand the question as a general concept? Can you explain touch DNA versus blood DNA? Okay, I think that's the question.
Please.
Yes, so if blood DNA from blood, blood is as a body fluid in general, would produce more DNA or leave more DNA behind than just touching an item. However, I can't say in this case as to which one those came from, as the knives may have been handled as stated by everyone throughout the family. I can't state whether or not the DNA is exclusively from blood or from epithelial cells.
Thank you. But based upon your analysis, were there chemical indications for the presence of blood on both knives?
Yes, there was.
Thank you. May I have a moment, please?
Amen.
Thank you very much. I don't have anything else.
Mr. Gilman, when you're ready.
Good morning, ma'am. How are you?
Good morning, and well yourself.
All right. So when you're examining these items of evidence, you examine essentially what's submitted, right?
Correct.
You don't go to the individual law enforcement headquarters and pick and choose what they give to you.
That is correct.
All right. So if they give you, for example, an actual physical knife, you would go through and do all of the swabbing yourself, correct?
Correct.
If they don't give you the physical knife, they just give you whatever the swabs are, you test from the swabs, correct?
Correct.
So you're entirely at the discretion of what is submitted to you as far as what gets tested.
Correct.
All right. And that system is automated, correct?
What do you mean by automated?
I mean, you don't go in and with like a pair of tweezers and pull out DNA, right?
No, I don't use a tweezer to go in. I do the process that we described.
Right, it's automated through machinery, right?
Yes, there are some hands-on portions, but yes, there are some machinery that helps with that.
And the peaks and valleys are essentially computer-generated results, correct?
Correct.
All right. The statistical analysis that you do has changed since you started in 2009, hasn't it?
Yes, it has.
Okay. And it used to be that you would give numbers like 1 in 15 and make like sounding like really horrible made up numbers for a statistical analysis, correct? And you'd have to count the number of zeros to describe the number?
Yes, we still do that. There's still big numbers now.
Okay. But it sounds to me like you said that the 2 times that you discovered Robbie Tower's DNA, that statistical likelihood was 700 billion times more likely, correct?
I stated that it's greater than 700 billion times more likely.
Okay. And then for the one instance where you indicated that you found Dima Tower in a mixture, it was 67,000, correct?
Approximately 61,000.
Okay. I think you said both 61 and 67, so it's 61?
It's 61,000.
Okay. And that's obviously closer to zero than 700 billion, right?
Yes.
Okay. And again, we're talking about a mixture, correct?
Yes, for
All right.
both samples.
And using the statistical analysis the way that you do, if you were to use a separate database than the one that you use, would you expect similar or different results?
Objection calls for speculation.
Would you be speculating, or do you know the answer to that?
I generally know the answer to that.
All right, I'll overrule the objection. You can answer it.
It would be slightly different, but I wouldn't expect there to be more than a 10-fold difference.
Right, so back when you're talking about the big, huge numbers, if we're talking 700 billion, the 10-fold difference would be 70 billion, correct?
Yes.
Okay. Nothing further, Judge.
State any redirect of the witness.
Did you find blood on those two knives?
Yes, I did find the indications for blood, yes.
Okay. And in addition, did you also find DNA from Robbie Tower and Dima Tower?
I was able to include Robbie Tower and Dima Tower on item 6.1.
And is that the bottom line of your report? In the most simplistic reductionist terms, is that the bottom line of your report?
Those are the results of my reporting, yes.
Thank you very much.
Is the witness free to step down?
Yes.
No objection.
All right, you may step down now. Thank you.
Okay, thank you.
Brooks.
As they get ready to bring in the next witness, let's bring in our guest for this hour to discuss. Joining us now from St. Paul, Minnesota, criminal defense attorney and former prosecutor Jack Rice. Jack, great to see you as always. Let's talk about the cross-examination. What do you think the defense was trying to get at there?
It's real interesting. You're looking at the numbers, and the numbers are huge, Kelly, obviously. But I think in the end, what you're going to see from the cross, certainly during closings, is to make the distinction, and I think this is where it'll go, is that they're going to try to make the distinction that there was DNA, and that DNA certainly could have come from the young man himself, from Dina. But at the same time, this was a knife that was a household item that anybody most likely would have touched in the first place. And so trying to make the argument that just because his DNA was on there doesn't mean he was the one holding the knife as it was being used as a murder weapon. And I think that's where they're going to try to go.
And you know, Jack, so when we had a situation in this case where defense counsel has said in opening statements that we don't dispute the facts, we know that he did it, he has said that he did it, so then why cross this witness? Why cross that DNA analyst?
It's a wonderful question. I always appreciate being on with you for that very reason. Because when you're thinking about cross-examining anybody, you're doing it to drive your narrative. If your narrative is that he did it, he actually committed the act, but for some other issue, maybe it's a mental illness question or it's something else, then the purpose of trying to go after a witness that undercuts your own theory doesn't make sense. As a result, it would have made more sense in my mind to actually not cross-examine this witness because you're not disputing it. You're not saying that what that person said was wrong. Instead, what you might have done was said, when you're studying DNA, when you're looking at DNA, you obviously don't have the ability to determine emotion, to determine what drove somebody, to determine whether somebody was mentally ill, to determine whether or not somebody was having a schizophrenic attack. Anything along those lines to say, just because he did it doesn't mean that he's not guilty by reason of insanity, if you're going to make an argument like that. That's far more consistent with the narrative.
Yeah, not guilty by reason of insanity. Let's go for manslaughter instead of a situation where this is a young man who premeditated this, which is, of course, what the prosecution is wanting with that first-degree murder charge, 2 of those. Jack, we're going to squeeze in a quick break, but stay with us. Jack Rice is going to be with us all hour, the rest of the hour. And coming up, we're going to switch gears and we're going to head to Nevada, where testimony resumes soon in the trial for a former porn star caught in a father-son love triangle. Court TV's Matt Johnson joins us live next for an update on this case against Devin Michaels. That's coming up next.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge watching Bull. Sundays on Court TV.
Let's check in on Nevada, where testimony resumes later today in the love triangle beheading trial. This is for Devin Michaels. Michaels stands accused of murder after prosecutors say she bludgeoned and decapitated her ex-boyfriend as he prepared to move into her Las Vegas home. Here in studio with us now is Court TV crime and justice correspondent Matt Johnson. Matt, so great to see you.
Nice to see you.
Catch us up on this case. I mean, what a lot of interesting parts here to follow.
Interesting characters, a lot of moving parts. Today is day 6 of testimony in the father-son love triangle centered around this defendant, the former porn star. Devin Michaels, accused of bludgeoning and beheading her ex-boyfriend, Jonathan Willett. He's the father of her 2 children, and she was married to the victim's other son from a previous marriage. So her defense also pointing the finger at him as the alternate suspect, the real killer. Well, yesterday, on Wednesday, the lead detective in the case took the stand and described the brutal murder scene. Take a listen.
You can see the bed, you can see the blankets. You can't see him yet, and you don't see him until, or his body, until you get closer to the front of it, of the bed, and then you start to wrap around. Then you can, at that point, you can start seeing the blood on the bed, blood stains, and then blood next to the bed at that point. And then when we get closer, or at least when I got closer, you could have that chemical smell that started burning your nose and your eyes at that time. We also noticed that there wasn't any blood spatter on the walls or on the ceiling. Just given the type of injury that we were seeing, you expect to probably see a little bit more blood in other places. And then just through that quick brief walkthrough, I didn't see any weapons or any devices that were believed to be used that would have severed his head off at that time.
So that was direct. Then on cross-examination, this detective was questioned about items that were not collected at the crime scene there in Las Vegas, including bedding from where the victim's headless body was found, and an Xbox that was in the room that the defense was arguing, or trying to argue, Kelly, that may have been able to record something, but we'll never know because it wasn't collected at the scene.
Matt, you mentioned Vegas. So this is Nevada. The jury can ask questions there.
Which is fascinating, right? We love that because we get the insight into what they might be thinking. So another unique part of this trial, in Clark County, Nevada, the jury is able to ask questions, and they've been asking quite a few, including the jury wanted to know more about the missing knife from the house, which could possibly be a murder weapon.
And at any time, was the missing knife ever described to you?
Yes.
If so, could you describe the missing knife? What type of blade? Was it serrated, the size or length?
It was described as kind of like a meat cleaver hatchet type.
Okay. Steve, any follow-up based on the jury questions?
Just, I don't know if you caught that part. It said, was it serrated or not?
She said no.
The jury also had questions for this witness, the last witness of the day yesterday, about DNA evidence. She's a DNA expert who testified that the defendant's DNA was found on plastic bags. Those bags contained the victim's truck keys and also his wallet.
On the cell phone, was DNA found on the outside of the phone or just on the screen?
Again, the swabs were collected by the Henderson crime scene analyst, so I'm not sure how they swabbed the phone.
Okay, ma'am. Given the blood on the cell phone, is it more likely that that area was swabbed?
Again, I'm not sure.
Testimony set to resume 2 p.m. Eastern. We're going to be all over the story, bringing it to you live, but just such a fascinating case. We're still in the state's case in chief, rapidly approaching the end, and then we're going to be in the defense case. And then the big question, you know, is this defendant going to testify? Because she had that outburst in court. I think she wants to tell her story.
Whew. We'll have to see. That would be quite something to watch, Matt.
Okay.
Thank you. Keep us updated.
Of course.
We're going to go ahead and bring in criminal defense attorney and former prosecutor Jack Rice. Jack, okay, Matt was talking about the jury questions. Do they allow that in Minnesota?
No, and I hate it.
Okay. Yeah, I mean, in Illinois,
really
we didn't have it either. So it's an interesting thing. I used to live in Vegas, but I wasn't an attorney at the time. And so, yeah, I haven't experienced that. It's always interesting to hear their questions, though.
Yeah, there's a couple of jurisdictions around the country that do this. And here's my real problem with. My real problem is that the state, the Commonwealth, the feds, whoever's prosecuting this case has the burden of proof, which means they're the ones who are required to present the evidence to convince a jury of something. It's not what the jury thinks, it's what's presented by the state, by the government. And the problem when you actually start allowing a jury to ask questions and not the prosecutor, what you're doing is you're actually spreading the burden. And the burden isn't exclusively on the state, which is the requirement. And so when you allow this, you basically negate the requirement of the prosecuting authority to prove their case beyond a reasonable doubt. I get the justice aspect of it, but remember, we also have due process, we have very specific understanding, and we have constitutional rights, including those burdens, and those burdens are incredibly important to make sure that they're actually protected. That's my problem.
Yeah, I would think it'd be a little more difficult. You have a strategy as a prosecutor going into your case, the way you want things structured, and then all of a sudden you have these jury questions, and you're like, ugh, I might have to switch up my strategy a bit. Jack, let me ask you, do you think we will hear from her?
You know, when you look at how she's reacted previously, I agree with you both. I think there is a lot of possibility here that she may very well take the stand. She has something that she wants to say. And in a case like this, looking at the evidence that's being presented, I think it may be really important that she have this opportunity and that she actually do it, because otherwise you're seeing a lot of evidence that is stacking up. And I haven't seen enough, certainly from the defense through cross or through their case in chief yet, that could negate the likelihood of a conviction. So there isn't the risk that you sometimes feel, but there's always risk anytime anybody takes the stand, because it's not the direct examination that gets them, it's the cross.
Yeah.
That's why it's so important.
Jack, so talk about the plea agreement she had. She was there, she was gonna plead guilty, she was about to, and then she decided to change her mind. It was extremely emotional. She was saying things like, they have manipulated everything in this case. She's innocent. As a defense counsel, when you negotiate a plea agreement, you think your client's gonna plead guilty, and then all of a sudden changes her mind. That kind of throws things off.
No, I can't count the number of times where I've seen something like this happen in my own practice, from many other attorneys who I know, and just being in the court system for the last 3 decades. You never know if a plea is going to go through until it goes through. You never believe that it's going to happen until it happens. Sometimes it's about the defendant themselves, about their stability, about what they want to do. But it's also, I think, really important for a defense attorney to spend as much time as possible, not just going through all of the evidence, that's a requirement, but also understanding the likelihood of success and failure and giving your truest assessment as to what that means. And more importantly, the ramifications if something goes one direction or another. All of those are important. So when a defendant sits down or stands in the well in front of a judge and pleads, they have to know why, what the likelihood of success and failure, what all the evidence says, what it doesn't say, and what kind of a case you would have put on if you could have. Those are all critically important.
Yeah. We'll have to see what happens. Jack, thank you so much. We're going to squeeze in a break. And coming up, we're going to head to a different state. We're going to go to Iowa, where closing arguments are getting underway. This is in the Metal Pipe Massacre trial for Luke Truesdell. That's coming up next. And welcome back to Court TV Live. I'm Kelly Craft. We're going to turn now to Iowa, where closing arguments are about to get underway in the Metal Pipe Massacre trial. The defendant in this case, his name is Luke Truesdell, and he is accused of beating to death 4 people. This took place last summer. Truesdell allegedly told police that he had done it to make a movie and that his head felt better after committing the murders. Before we get you into court, here's Court TV field reporter Cody Thomas with more on the case.
Luke Truesdell is charged with 4 counts of first-degree murder for allegedly beating 4 people to death with a metal pipe. On June 5th, 2024, Brent Brown, Ramondis Cooper, Amanda Parker, and Kiana Ryan were found beaten in a detached garage in rural Iowa. Truesdell was at the scene when police arrived, and they were told he found the victims. He was questioned as a witness, but he seemed to confess to the murders. According to court documents, Truesdell said he did it, quote, to make a movie. That statement will not come in as evidence because he had not been read his Miranda rights. But what can be used at trial is police body cam footage where Truesdell says, "I hit them each," and says, right inside the door on the right is a metal bar when he was asked what he used to hit the victims. He also told officers, "My head don't hurt no more. I'll never do it again. I feel so much better." Truesdell was arrested that evening. He has pleaded not guilty.
In that case, the judge is still reading the jury instructions, so we're going to wait for those to finish. Then we're going to have the closing argument. So, of course, we're going to bring you those when those begin. But in the meantime, let's bring in criminal defense attorney and former prosecutor Jack Rice to talk about this case. All right, Jack, we got you all over the place today. We had Florida, we had Nevada, now we have Iowa. In this case, defense counsel is saying that the father, we should be looking at the father, not the man who's on trial.
Well, the problem, of course, is you have the admissions. I mean, that's really the problem when you have that. And when we think about this, I mean, frankly, it was already a success when you kept out the confession. Sometimes when we're fighting these things, they're one fight after the other. The fact that the defense team was able to keep out the confession in the first place, arguing Miranda, that's sometimes quite extraordinary. But you get these other admissions that can slide through the cracks. And the problem is you're going to have a very difficult time saying, yes, it was the father, when you get the defendant himself actually making admissions to "I hit them each once." And that's something that's going to resonate with the jury because they love hearing, they love seeing. This is the critical part. They love seeing statements like these because those things matter and they stick with the jury.
Yeah, they do matter. I will say in this situation, when they have played that body camera footage, the wind noise is so strong. It's clear, but yet it's not clear. So when they were having the witness on the stand who was wearing that body camera footage, they had to have him repeat what was being said. So this isn't a situation where it's so clear, I hit him. At least I had trouble hearing it, Jack. But to your point, yeah, having that kind of admission when you're a jury, I mean, how do you argue against that?
No, it's so great because that is the only piece that helps. Is to say, is this what, in fact, what this officer claims he heard? Is this actually what the defendant himself said? Is this what Luke actually said? Or did he say or mean something else? And there is a little space there, and there's a room to operate, because sometimes, certainly on the defense side, what we're regularly doing is we're working the seams. We're working what's clear on 2 different pieces, and we're trying to drive down the middle and sort of cleave those pieces apart. That's how we regularly are operating. And when you're talking about a jury, if they don't hear it, just like you said, it was unclear for you, if they don't hear it and you claim that the officers heard something else, now what you're going after is the biases of the officers who are thinking, ooh, I can clean this one up real quickly, I can prosecute him, and he can be the one found responsible, even if it wasn't him. Now that may be the angle they're trying to go because, frankly, sometimes there's nowhere else to go.
Yeah, sometimes you don't have a choice. Jack, thank you. We are going to squeeze in a break, and when we come back, we're going to tell you more about all the other cases, as well as this one that we are covering here at Court TV Live. We'll be right back.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
I helped right now, died.
Don't you have the blood of both these men on your hands?
I feel guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
And welcome back. We are going to go back now to Iowa, where closing arguments are just moments away in the murder trial for Luke Truesdell. He is charged with the beating deaths of 4 people in Lynn County last year. The prosecution says that Truesdell ambushed the victims, killing them with a metal pipe. he faces life in prison without parole if he is convicted. As we wait for those closings to begin, we did hear one of the parties inside the courtroom say we are ready for closing. So just a few minutes before those do begin, let's bring in criminal defense attorney and former prosecutor Jack Rice. Jack, kind of gear us up for the closings. What do you think we're going to hear from the prosecutor in this case? I mean, we talked about that body camera footage, so you have an admission. What do you think we're going to hear?
Yeah, it's incredibly powerful. Let me think of it like this. So I'm teaching a course tomorrow where I teach lawyers how to try cases, and I've been doing this for many years. And one of the things that we talk about is this, is that some people imagine that opening statements and closing arguments are different, or excuse me, the same. They're just a little bit more aggressive. That's not true. Actually, this is about something different. When you think about closings, openings really are about simply saying, this is what's coming, Your Honor, or to a jury of 12, if that's where you're sitting. But closings is really about taking the evidence that's presented and showing what it means, what it leads us to, what it inevitably takes us into this space. And when you have evidence like this, you can look at it two different ways. You can say the evidence itself speaks for itself, but you can also take it a slightly different way and say, but for Luke Truesdale, who else could have done it truly? Was the father in this position? Was the father in the room? Was the father near the pipe? Was the father making admissions? Was the father doing anything else? And what you do is negate the alternatives and then say, there is nobody else but Luke Truesdale. There's nobody else who could have done this. And in fact, when he said that he hit each of them once, he meant it. It's exactly what he did. It's exactly why we're going where we're going. Because, ladies and gentlemen of this jury, you have no alternative but to go down this path, because it's his own words. It's his own emotions. It's his own drive. It's his own physicality that put him in the room, that reached over and picked up the pipe and swung it and connected with the heads of each of these four victims. He is the one who murdered them. And you have to come at that with, frankly, both fists, because that's how you take a jury. You grab them by the lapels and you say, you're coming with me because I'm going to take you where you must go, so you have no other option.
They have something else to work with in this case, drugs. They said that he was high on drugs. We heard a detective talk about it on the stand. Let's go ahead and play that, Jack. I'll talk with you about it on the other side.
And you said you last used a couple days ago. You're not going to have an overdose or anything like that?
No, sir. I smoked a little, I believe, this morning.
What? Meth?
Yeah, I can say yes, but I'm not a chemist.
That's right.
Okay, so that right there is Luke confirming that he had, in fact, smoked something earlier.
Yes.
So at this point, not only did we have let's call it an educated belief, but now we have a statement, I smoked earlier, so we know he's high.
An admission, yes.
Okay. Now, based on your training and experience, could you venture a guess which substance he had been smoking?
Based on my experience, I believed it was meth.
All right, so they had meth. He had meth in his system, Jack. We're getting word that they are about to start. I don't believe that we have audio yet inside for the closings, but as soon as we do, we'll go out there. But Jack, what'd you think of what the detective had to say on the stand?
It's one more brick in the wall, isn't it? One more brick, and that's sometimes how you do this. Sometimes the bricks are huge. I hit them. Sometimes the bricks are smaller, but still important. I was smoking this morning. I have methamphetamine in my system. I did this. I was feeling that. And what this does is this allows a jury to take all of these pieces of evidence and say, how does anybody get to a place where they walk into a room, they grab a pipe and they start murdering people? Meth is one good explanation.
Yeah. State has started, Jack. Let's go in for closings.
Mass murder in Maryland. Ramondis Cooper, Amanda Parker, Kiana Ryan, and Brent Brown. Ambush, bludgeoned, and left bleeding on a concrete floor in Lon Brown's outbuilding. There's blood, just a lot of blood. That's what Matt Brown told 911 dispatchers when he arrived at his father's property after being summoned there. Initially believed to be carbon monoxide poisoning, but as soon as first responders arrived, they knew that wasn't the case. Trooper Fairbanks said it best. Carbon monoxide does not cause your face to collapse. Cause of death, blunt force trauma. Lacerated, abraded contusions, hemorrhaging, skull fractures. These are the types of injuries that our medical examiner described most commonly seen in high velocity, high impact vehicle collisions. But for Roe and Amanda and Kiana and Brent, there was no vehicle. There was only Luke Truesdale and a metal pipe. What the evidence showed you in this case, ladies and gentlemen, is that on June 5th, Lon Brown was at home at 3699 East Otter Road in Marion, Iowa, which is in Lynn County. That he was just finishing up his lunch when the defendant pulled into his driveway, parked out in front of his house, and got out of that vehicle with his dad, Larry Truesdale. Brent and Kiana were home that day too. Brent and Kiana were planting flowers, trying to improve the landscaping, enjoying a nice sunny but windy June day. Roe went to pick up Amanda from work. You see them later arrive on that green motorcycle, where they also interacted with Brent and Kiana when they were outside, where eventually the defendant met them in that front yard area. And that surveillance video captured their last few moments. Wait, Michelle, come here. Roe and Amanda are walking towards the entrance of that outbuilding. Larry and Luke also enter the screen. As Lon told you, Luke was sent out to check out that inboard motor on that boat. He wanted to part it and get that boat out of there. And that's exactly where Larry headed. Luke followed the same path into that outbuilding that Ramondis Cooper and Amanda Parker went. That's the last time that anybody saw Ramonda Cooper alive. Amanda came back out. Drink in hand. Stop to talk to Brent. Talk to Kiana. Went back in that outbuilding. Never to be seen alive again. But that's not the last time that we hear Amanda. And I know the acoustics in this courtroom are terrible, and there's a balance between using the overhead speakers and using a sound bar. But I submit to you, ladies and gentlemen, that when you take this evidence back into the deliberations room, you'll be able to hear it better. And you're going to be able to hear that break. That break in the wind, and hear Amanda scream. Hours, 23:41, I believe is the timestamp that I want you to listen to in that exhibit. Where just for that brief moment, that wind breaks and you hear it. Brent and Kiana heard it. Stopped them in their tracks. And they went to check it out. And as they're going into that outbuilding, Luke Truesdale comes out, does an about face, and follows them in. The last time you see them alive.
Coming up, we're going to have more from the closing arguments in the metal pipe massacre trial for Luke Truesdale. We'll be right back.
we have all the jurors up?
Yes, Your Honor.
Okay. State, do you have your witness here?
Yes,
All right, is the state ready to proceed?
it is.
Defense ready to proceed?
Yes, Your Honor.
All right, let's bring the jurors in. All right, everybody may be seated. Welcome back, members of the jury. All right, state, please call your next witness.
State calls Dr. Russell Vega.
Stand right here, face the clerk, raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Okay, so you come over here. Thank you. Right up that way.
Are you ready, state?
Yes, thank you.
Adjourn, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Will you please tell us your full name and spell your last name?
My full name is Russell Scott Vega. The last name is spelled V-E-G-A.
Dr. Vega, what is your profession?
I'm a forensic pathologist or medical examiner.
All right. And what are the duties of a medical examiner?
The medical examiner's job is to investigate certain deaths. Those deaths are specified in statute or state law. And more or less, the deaths that the medical examiner is supposed to investigate are non-natural deaths, violent deaths, deaths that occur as a result of anything other than natural disease.
All right. And what is your jurisdiction as a medical examiner?
As the district medical examiner for this current district of District 12, my jurisdiction includes DeSoto and Manatee counties, as well as Sarasota County.
Will you tell the jury a little bit about your formal education, please?
Certainly. I got my undergraduate degree at Florida State University. I majored in physics and biochemistry at FSU. After graduating there, I went to medical school at the University of South Florida in Tampa. Following medical school, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology is the subspecialty of medicine that deals with diagnosing diseases by looking at fluids, different laboratory tests, biopsies, organs removed at surgery, and by doing autopsies. And after all of that, I did a 1-year fellowship or subspecialty year in forensic pathology, and that's the branch of pathology which specializes in autopsy and in death investigations.
What is an autopsy?
An autopsy is an examination that is performed on somebody who's died, and that exam can be performed for different reasons, but generally it's to identify any diseases, complications, anatomic abnormalities, injuries, or other things which might be of interest to either doctors who order that or in our realm for medical examiner autopsies to figure out what the cause and the manner of death are.
All right, thank you. So I want to take you back to September 3rd of 2023, Doctor.
Yes.
Did you go to the death scene in this case?
Yes, I did.
And you tell the members of the jury, what are the advantages or the reasons for a medical examiner such as you to go to the death scene itself?
By examining the scene of a death where the body is still there, there is certain information which can be gathered, which can be helpful in the coming process of doing the autopsy at some later point, or to gather information which might be useful for law enforcement or other agencies at that point in their investigation. Some of the things that are of value in that scene investigation then are the ability to try to put together the circumstances that led up to the death, the evaluation of where the actual injuries that led to death occurred and whether or not they occurred elsewhere or at the site where the body was, and to get an idea of what the nature of the injuries or potential injuries, before we get out there, perhaps we don't know, but the nature of the injuries that led to the person's death. Finally, we might get information that leads us to a rough estimate of how long a person has been deceased and at that site.
Okay, and that is a rough estimate, isn't it, Doctor?
Very rough, yes.
Okay, because on TV shows, you always have a detective saying, how long has this person been dead? And the doctor says 2 hours and 27 minutes. Is that possible?
It is possible with certain elements, such as some kind of device which is tracing an individual's vital signs at the time, or even better, a surveillance video or something of that nature. Right. But just based on the autopsy findings, it can almost never be that precise.
Okay, thank you. So after you went to the death scene and did that examination that you talked about, looking at the circumstances surrounding it, the nature of the wounds, et cetera, did there come a time when the bodies of Robbie and Jennifer Tower were transported to the morgue?
Yes.
Okay. And did you perform an autopsy on both Mr. and Mrs. Tower, Robbie and Jennifer Tower?
Yes, I performed autopsies on each of them.
When did those autopsies take place?
So the autopsies were performed on September 3rd of 2023.
Okay. Doctor, I'm showing you have been marked for identification as States Exhibit 34A through 34K. And that includes double G, so 34G and 34 double G. Take a look at those for me, please.
Certainly. I've reviewed them.
Do you recognize these photos, Doctor, as the photographs that were taken at the time you autopsied the body of Robbie Tower?
They are, yes.
Are they a true and accurate depiction of the procedure of the autopsy that you conducted?
They are.
Your Honor, I'm offering State's Exhibit 34A, 34B, 34C, 34D, 34E, F, G, 34G, 34H, 34I, 34J, and 34K. Into evidence, please.
Any objection to 34A through K and double G?
No objection, Your Honor.
All right, they'll be admitted. You may publish them at your leisure.
Thank you.
Thank you.
I think it's better if you put those lights down and keep them.
Is it routine practice, Doctor, to take photographs during the course of the autopsy?
It is.
Why?
Photographs are the best form of documentation that we have, especially for external findings on the body. I can make notes, I can make verbal descriptions of findings, but nothing conveys the nature of many findings, especially injuries on the body, like a photograph does.
Let's look first at State's Exhibit 34A. And we're going to talk about some of the markings that you have as part of the autopsy procedure, specifically the letters that we find on Mr. Tower's body.
Yes.
So we're going to go first, even though this is not in chronological or numerical order on your autopsy report, but we're going to go first to the stab wounds on Robbie Tower's face, please.
Yes.
And by the way, were you able to document how many stab wounds were inflicted on Mr. Tower?
I was, although the determination is, it may not be exactly what somebody else would have determined with the same findings, because there's such a variation in terms of how deep or how severe or superficial the injuries are, that some of them I didn't classify necessarily as a counted stab wound or cut wound, but I did note the other injuries in my report. So in total, for Mr. Tower, I counted 68 stab or cutting type wounds, with more that were small or superficial or subtle wounds that were probably sustained in the same way, but not totally characteristic stab or cut wounds.
But at least 68 distinctive stab wounds that you could identify as such.
Yes.
Thank you. So let's look now at State's Exhibit 34A, and I'd like to talk about the wounds that you cataloged on the face of Mr. Tower. So let's talk about those, if you would, please.
Certainly.
So we can start anywhere you like, Doctor. If you want to start on the upper right cheek, or upper left cheek, pardon me.
Certainly. So the injuries that we see on the face here are this largest wound, which was labeled with the letter H, the much smaller and very superficial wound labeled T here, and then the wound on the chin labeled I. And I think it's maybe important to notice that, or to note that when I was assigning these letters, to some extent, it was largely a random application. I did it based on the letters I had at the time and what I was examining at the time, and it doesn't have any correlation to timing or anything else with the injuries. So of these, H is the most visible on the skin, obviously. I believe, is 2 separate wounds which are just joined. In other words, they were very close together and seemed to form one single wound. Of these wounds, none of them caused any major injury. The injuries really just involve soft tissue only.
And in addition to these that we can see in 34A, I want to move to 34B. And take a look at the wound that you called S, which was also included as a stab wound to the face.
Yes.
Can you please tell us a little bit about this wound?
This wound is a wound which involves the back edge of the ear. So this is the left ear. So in this photo, the nose would have been oriented here, and the back of the head here, the neck over here. And this wound essentially cut through all of the tissue over the back edge of the ear, essentially at the same level as the ear canal here.
Right, let's look at 34C, please. Now we're going to move on to your recitation of the stab wounds of the back. And the back of the neck, I should say. So let's look at this photograph, 34C, and there's quite an extensive amount of lacerations here. So would you please just start wherever you like and talk about them?
So all of these injuries are relatively similar, meaning that are all injuries that are inflicted with a sharp instrument like a knife. There are some which are longer on the skin than others, or that are wider. I would not take that to mean that they were inflicted with a different instrument. They might all have been inflicted with the same instrument. It depends on what's done with that knife once it's in the skin. It's very easy to flex a little bit along the skin with the blade and cause the stab wound to be longer on the skin. And also the tension on the skin is what determines how wide the injury appears here. So even though these injuries on the back of the neck and the upper back have varying appearances, they all were potentially really sustained in the same way with a stab with a knife. Of these injuries, the vast majority of all of these, that includes the clusters of injuries on the back of the neck, the very upper back here, and lower in the back, that for the most part, these injuries involved only soft tissue and did not penetrate to any deeper major blood vessels or organs.
So would a person have been able to survive if they had only sustained these injuries, and even the ones on the face?
Potentially, yes. Long-term complications, of course, could ensue, but in the short term, yes.
I understand. Okay. So I would also like to go to 34D because that's hard to see in this photograph. And there's a stab
This here? This is,
No,
oh.
I'm sorry, my 34D.
Oh, I'm
No,
sorry, yes.
I'm sorry, doctor. Photograph 34D. Because there's a stab wound on the neck end, which I'd like you to talk about. And I wasn't able to find a photograph that included that on the larger 34C. So can you tell us a little bit about N?
Yes, although It will help if I refer to my records here. And, yeah, and
It appears to be a cluster of a number of wounds that you just cataloged as M.
yes. So this cluster is involving the left side of the neck. What I describe in my report is it's posterolateral, meaning it's the side of the neck and toward the back. So the back left side of the neck. And there are several stab wounds that you see here. I counted this as 5, but some of the stab wounds I think that you can see on the edges of this photo were included in another grouping.
Let's go now to, I'm going to backtrack a little bit and go to a wound on the scalp. We're going to look at State's Exhibit 34E. And that's going to be the first wound that you talked about in your report.
Yes.
So tell us a little bit about this.
For orientation, this is the top of the scalp. So this is the very edge of the left ear that you're seeing here. The right ear would be more or less over here in this photograph if it were extended. And this is a short stab wound, essentially right to the top of the head.
Superficial as well.
It is. Of all the injuries that we've discussed so far, none of them, with the possible exception of one, really caused any significant deeper injury. It was all soft tissue injury.
Let's move next to State's Exhibit 34F. And now we're going to talk about the left side of the neck.
Yes.
And the injuries that were inflicted to Mr. Tower. It looks like there's a lot of clusters there. You can just go through that for the members of the jury, please.
Yes. And I would point out that we've already looked at in closer detail at this cluster here and at the injury to the left ear here. What we really haven't seen before is this cluster over the left upper neck and cheek area. It's labeled J, and then these other clusters which are at the base of the neck and over the top of the shoulder region here that are M, L, R, K, and G.
Now I'm going to I'm going to jump ahead a little bit, and I'm going to go to the larynx because that's how you discussed it in your report. So let's look now at State's 34G. And first of all, will you tell the members of the jury, might be oversimplifying, you probably know this already, but where is the larynx located?
So the larynx is the medical word for the voice box. The front part of the larynx is what you feel in your neck, is the Adam's apple. What we see in this photograph is the larynx removed from the neck. And for orientation, this is the base of the tongue here. So this is the front of the specimen. This is the back of the specimen. This is the larynx structure itself, and the larynx has a cartilaginous backing to it that can be pretty hard. I opened that so that I could look at the internal surface of the larynx. This is the epiglottis, and that's the flap which closes over your airway when you're swallowing or eating. This is your vocal cord here and here. This structure is called the false vocal fold. It looks like a vocal cord, but it's not. The rest of what we see is injury. There's some bruising here and a cut here in this tissue to the side of the larynx. And then there are large cuts here, here, there, and here. There's also one there that you can see a little bit of bruising from on the other side here, which these cuts go through the full thickness of the tissue. And these were cuts which were the endpoints of stab wounds which originated on the neck. Some of those we've seen, those were the stab wounds of the left side of the neck, mostly in that J cluster. And then on the right side, probably at least one was from some wounds on the right side of the neck that we have not looked at yet.
How many separate perforations were you able to see in this, in Mr. Tower's larynx?
I found 6.
Now, I also see some, what is that white, is that used as a trajectory rod, that white thin object that we see on, yeah, what is that?
This is really, it's just a small wooden stick that I improvised to use to hold this open, because there's a lot of tension here. And if I don't have something holding it open, it'll close and you won't be able to see the structures here as well. So I just used this essentially to prop it open so I could photograph the findings.
And those other instruments are also to keep it open?
Yes, these are what we call forceps. They're like tweezers.
Let's look at another picture of the larynx, please. Maybe might be helpful. This is 34 double G. And can you just orient us? Is there anything on this photograph that helps the jury to see those 6 separate perforations of the larynx?
Well, the perforations here to the side, I think you get a better feel for the extent of this. This is I'm encircling the opening here on the left side of the larynx. You can see that one perhaps a little more clearly too, and then you can better appreciate the bruising you see in the tissue adjacent to that here in the soft tissue or mucosa, which forms the wall of the larynx on both the left side and the right side here too, to some extent.
What happens to somebody's larynx or voice box when they sustain this kind of injury?
It would certainly impede your ability to vocalize or speak. Because the larynx isn't transected, it's hard to know exactly what that effect would be. It's possible that one still could have been able to vocalize or speak some, but it's also possible that that might have been greatly impaired.
I'd like to go to State's Exhibit 34H now, and we're going to look at some more injuries to Mr. Tower's face and his head. So can you please tell us about T?
Yes, T is a single stab wound. I want to make sure that I separate that out for you.
That's found under your...
Yes.
Yeah, on page...
So T does, even though it's not particularly long, it does potentially go deep to the level of where the carotid artery was. And unfortunately, because there's a lot of injuries which are coalescent under the skin, it didn't allow me necessarily to be able to correlate a single individual internal injury with the stab wound on the outside that caused it, because they commingled as the stab wounds went into the tissue. But it's possible that T caused an injury to the carotid artery, which is deep there.
So are you telling us that you don't know if T was the entrance point to injure the carotid artery, or that you're not sure if the carotid artery was actually injured?
The carotid artery was injured. I just wasn't sure which stab wound caused it.
Thank you.
Yes.
And then let's look at O, that's on Mr. Tower's temple, or above his ear.
Yes. So O is not a deep injury, and normally I wouldn't necessarily have categorized that as one of the injuries that I would count and put a separate letter to. But in this case, I chose to do that to accentuate this particular finding. This is a scrape on the skin, what we call an abrasion. And the reason that I included this is it's a patterned abrasion. The pattern consists of multiple parallel lines that are perpendicular to this single line here and extending downward from that. You see 3 or 4 of them there pretty clearly. I believe this is the same thing here, but they're blending together in this broader area of scraping here. This injury was probably sustained as a single impact or brush with a knife or possibly some other implement. Maybe this was from 2 impacts, one causing this and the other causing this with the scraping, almost looking like the teeth of a comb there.
All right, thank you. Then, I know that there were numerous stab wounds to Mr. Tower's right and left shoulders, but I want to move on to stab wounds of the chest, please. And what I'm going to do, I'm going to go back to 34A so that we can look at those again. Please. So we used this photograph, 34A, to talk about the wounds on Mr. Tower's face. Now I'd like to see if we can't focus on his chest, of which there are 4 wounds. So let's talk about those 4 perforations, please.
Certainly. The 4 I think you're referring to are the labeled injuries of F, C, B, and A. There are a few smaller superficial injuries that are really scratches, essentially, up here, at the top left of his chest, and then down here on the upper part of the right side of his abdomen. Those are the kind of injuries I was talking about before that I didn't necessarily number, but were additional injuries that he had sustained. With regard to the 4 numbered ones, though, A is the largest of these and perhaps thus draws your attention most immediately. These are all shorter on the skin. All of these penetrated some distance into the soft tissue. None of these injuries really caused, or these stab wounds caused any deeper injury, only soft tissue injury, with the possible exception of B, which probably nicked the internal mammary artery. It's a small artery which runs inside, well, on the underside of the sternum. And based on the way that the dissection is done, I thought that B had nicked that artery, but it was just hard to tell. It would have been a small injury. Over time, it could have caused some significant bleeding, but not one that I would have expected to immediately cause death.
So again, with these 4, if medical assistance had been forthcoming, they would not have been fatal.
That's correct.
I'd also like to look at stab wounds of the back. Can you have those cataloged on page 9 of your report? And again, I'm going to revisit one of my exhibits, states 34C. So let's talk about those wounds to Mr. Tower's back, please, his upper back.
Yes, so the injuries to his back, especially if you mean by upper back, all these that you can see in the letters. Yes, sir. Yes. Again, these are injuries which are of different sizes and shapes, but all, in my opinion, sustained in the same way with a stab wound by an instrument like a knife. Of these, I have small clusters such as DD, and then I have individual injuries like FF, BB, EE, and GG, and a small cluster here of HH. Of all of these injuries, there was only one which was in the cluster of DD, which caused more than just soft tissue injury. And one of those in DD appears to have caused a small injury in the spinal cord by passing deep enough to go past the spine, the bones around the spinal cord, and to nick the spinal cord there.
And then I'm going to go to 34I to continue with the injuries to the back. So this encompasses the injuries that we just saw and a few more that are down on Mr. Tower's left side, sort of his shoulder there, on his left shoulder, and also on his left arm.
Yes.
So can you just briefly go through those?
Yes. So this is an injury to the back of his left shoulder, an injury to his lower left chest on the side, and an injury to his left forearm. Of these, this is again the most visually noticeable of the injuries, and I would call this more of a slashing kind of injury. It was not extremely deep, but does have a broad length on the skin. This involved only soft tissue without any other major injury, as did this injury I. The stab wound K went a little more deeply and did have a little penetration into the lung cavity, which is right below there. And it put a small stab wound into the lower lobe of the left lung. It was a small penetration, and there was very little bleeding, and there was really no collapse of the left lung on that side. So I think over time, that could have been a potentially serious injury, but I believe that Mr. Tower died before it had a chance to manifest it being more serious, and that it really didn't cause him any particular impairment during the time of his life following the first infliction of injuries till the time he passed.
Now, there are also numerous injuries on the upper and lower, especially the upper extremities, the arms, left and right arms, and also some to the legs, both the right and left leg. But I want to talk to you about defensive wounds, if any. Did you see any sign of defensive wounds?
He did have injuries to his hands, which can be considered or might be described by some people as defensive wounds.
Okay, so let's look at those photographs, which are 34J, and I have another one that's just a close-up of 34J, 34K. When you look at those, can you tell if those are defensive wounds?
What I can tell you is that this particular injury is consistent with a knife blade coming across the finger like this. And it's characteristic of the kind of injury one would sustain while trying to grab a knife.
told us that, based upon your count, it appeared that Mr. Tower sustained approximately 68, give or take, 68 wounds. Can you tell us what was the specific cause of Mr. Tower's death?
Yes. Despite the vast number or the high number of those stab wounds, the stab wounds that really were significant were the ones in the neck that ended up injuring a couple of different large vessels. The carotid artery we've already talked about was one. Another artery was the subclavian artery, which is the artery that goes from the aorta over to the shoulders, goes through the base of the neck. Of course, there were many other smaller vessels which were cut as a result of all of these stabs. It was the bleeding from all of those injuries, especially the carotid and subclavian arteries, but all of those injuries which were his cause of death.
And do you have an opinion as to the manner of Mr. Tower's death?
Yes.
Can you tell us what that opinion is, please?
In my opinion, the manner of death was and remains homicide.
I want to move on now to Jennifer Tower, please. Dr. Vega, I'm showing you what have been marked for identification as States Exhibit 33A through 33Q. Look at those for me, please. Do you recognize these photographs as having been taken during the autopsy of Jennifer Tower?
I do.
Are they a true and accurate depiction of Jennifer Tower at the time of her autopsy in September of 2023?
Yes.
Your Honor, I'm offering States Exhibit 33A through 33Q into evidence.
No objection.
33A through Q will be admitted. You may publish them at your leisure.
As to Jennifer Tower, Dr. Vega, were you able to count the number of penetrating stab wounds and superficial wounds that were inflicted?
Yes.
How many?
As with Mr. Tower, there were some small injuries that I did not include in that count, but the injuries that I did categorize that way totaled 79.
First place, I would like to look are the stab wounds to Ms. Tower's face, and we're going to be reviewing State's Exhibit 33A. And if you would just start wherever you like, Doctor, and just describe for the members of the jury what your findings were.
Well, as you described, this is a photograph of the left side of Ms. Tower's face, and here we have fairly distinct single marked stab wounds A, B, C, and D, and then there's a large cluster here designated as E, which you can see some but not all of, and then there's this cluster at the very upper part of the left side of the chest, perhaps you might say the top of the shoulder, designated as F. But focusing maybe on these four, A, B, C, and D, these were injuries which, like the other injuries that we've seen in Mr. Tower, are different sizes and shapes, different amounts of gaping, but basically all consistent with stabbing by the same or similar knives. All of these injuries involved the soft tissues and no real major vascular or vital organ injuries. So like very similar actually to Mr. Tower, the facial injuries largely superficial.
Okay, let's go to 33B, please. And now we're looking at the right side of Jennifer Tower's face and neck. Can you describe this group of, this cluster of stab wounds, please?
Yes, this cluster of stab wounds we see here is remarkable for a couple of things. And maybe one thing that I didn't point out as much in the other cluster as well is that those stab wounds, not A, B, C, and D, but the E ones, you know, we didn't really talk about those, so I'll save that for later. I apologize.
Well, I won't remember it later.
I will. So in W, what we see here is that they're all essentially parallel to each other. They're all horizontal to the ground. It's not a very tight cluster, but the fact that all of these are roughly parallel to one another suggests that these were all inflicted on or at about the same time, with the position of the assailant and Ms. Tower here not changed. And to me, that suggests that she was already incapacitated at the time that these injuries were sustained. Of these, and I'm going to have to refer to my my notes here. These involved a lot of soft tissue underlying. One of these perforated superficially into the right side of the larynx. One caused injury to the internal jugular vein, and one caused a transection or a complete cutting of the carotid artery near the skull base. Like previously, I can't tell you which of these injuries specifically here caused which internal injury, because once you get past the skin, they commingled too much and I was unable to separate the tracks.
But perforations of the carotid artery and the jugular vein are lethal, may not be. Are they lethal?
Would be expected to be lethal, yes.
stab wounds do we find in this grouping?
I described this as 14 separate wounds. There are a couple, like this looks like it might be one long wound, but I counted this as 2 separate wounds. It appeared to have 2 separate tracks, at least for a brief time, under the skin.
And you said that the assailant and Ms. Tower, the victim, were essentially in the same position for all of these stabbing?
That's what the clustering suggests, yes.
Thank you. Let's go now to State's Exhibit 33C. And now we're looking at the left side of Ms. Tower's face, her upper cheek. And let's talk about these injuries, please.
So this is almost a mirror image of what we saw in the last photo, the left side of the face. So here's the left ear. And of these injuries, you can see D and a little bit of B here that we already described. This cluster, very much like W, has many injuries which are all at essentially the same orientation. They're all relatively parallel to one another. And this clustering suggests that the injuries were all sustained at or about the same point in time, where the assailant and Ms. Tower were not moving relative to one another. Again, likely that she was already incapacitated at this time. These injuries also became commingled underneath the skin, so I was unable to specifically separate out the wound tracks of them as they went deeper, but at least one of them injured the left internal jugular vein. So we saw an injury to the right internal jugular vein from the other side, and this cluster of injuries caused at least one injury to the left internal jugular vein.
What is the function of the jugular vein, Doctor?
The jugular vein brings all of the blood from the brain and much of the face and the other tissues of the head and neck down to go back to the superior vena cava and back to the heart.
What is the function of the carotid artery?
The carotid arteries on each side are the main arteries which supply blood to the brain. They also supply blood to the eyes and the facial muscles and essentially all the structures and tissues in the head.
Let's look now at States 33D, and this is going to be another cluster of wounds. That are delineated as X. So,
Yes.
can you tell us about that grouping?
Yes, I have a small grouping of injuries labeled X. There are other injuries, Y, A, Z, perhaps we'll see in other photos, but these injuries are to the back left side of the neck. So this is that cluster that we just looked at in E. And these injuries involve soft tissue, but no major vascular or vital structure injury.
Talk about this. Would you describe that as a cluster, or are they too far apart to be a cluster?
I think a cluster is a reasonable description for how I chose to document and photograph these injuries. They have similarity to the other ones that we've seen, the other clusters, in that the injuries are relatively parallel. They're not quite as tightly clustered, and there is a little variation in the angle, but I suspect that these injuries were also sustained in a similar way after Ms. Tower was essentially incapacitated.
And just to remind the jury, when you first arrived at the death scene, describe how the victims were lying. Were they prone or supine?
They were both prone, meaning they were lying face down.
So Ms. Towers would have been in this position, and so would Mr. Towers. Mr. and Mrs. Towers would have been in this position face down when these wounds were inflicted. if what you say, well, I know you can't opine about that, but.
Objection, counsel testifying.
Sustained.
Would these wounds have been inflicted after Ms. Towers was incapacitated?
I believe so, yes.
Now I want to talk about the stab wounds to Jennifer Towers' chest. So I'm going to move on to State's Exhibit 33F. And this is a close-up, doctor, so if you can just tell us about O and P and the injuries and the damage to Ms. Towers' body.
Give me just a moment, please.
It would be on 5 and going over to 6. Page 5 and 6.
Yes. Okay. This is this particular photograph doesn't have landmarks to guide the location, so I wanted to make sure I was looking at the right part in my report.
This was for a matter of decency, so I just.
I understand. So these two are on the left lateral side of the chest. So the area of the chest is lateral and upper. So in this region here, what we might call the upper flank. As you can see, they're relatively close together, but not overlapping, and have a similar orientation, but unlike the other injuries that we saw that were like that, there's only 2 of them. It's not not a larger number, so I don't think I would designate this as a cluster. But there are 2 separate stab wounds there that have similar paths. They both involve soft tissue, and the wound O here just goes deep enough to penetrate into the left lung cavity. But that's all. It didn't go any deeper, so it didn't even injure the left lung at all.
Right. Now I'd like to move on to stab wounds of Jennifer Towers' back. We're going to be looking at State's Exhibit 33G. What's significant about this photograph and the injuries that are depicted, Doctor?
So for reference, we've already talked about these wounds up here in the neck, clusters E and X. I mentioned Z briefly, but we didn't describe it any further. And then we have what I grouped as E and C and B. Of these injuries, I think you'll notice right off that they don't have that same clustering effect of being closer together and parallel in the same orientation. So I can't really make any opinion as to how or what order or what the relative condition Ms. Tower would have been in at the time that these injuries were sustained. Of all of them, BB, CC, and EE, all of them involve only soft tissue and no significant deeper injuries.
You also found during the autopsy stab wounds of Jennifer Towers' right shoulder, and those are depicted on State's Exhibit 33H. Can you address these injuries, please?
Yes, and this particular photograph really highlights injury Q here. There's an injury R here, which you see most of, but not all of here. It's at a different orientation, but close by to Q. These are essentially similar to O and P that we saw before. Two wounds that are relatively close by, but don't have the same orientation. Of these, neither one of them causes any particular underlying injury, just soft tissue injury.
Let's move on to Ms. Tower's right arms. Right arm. And we're going to look at State's Exhibit 33I. Can you talk about these two injuries that you've labeled M?
Yes. So M has, actually, I'm going to take a moment to review what I have written here. I want to make sure I get this correct. Yes. So in this particular photo, we see two injuries, one of which has its letter covered. This is a superficial injury. It does not involve anything but the subcutaneous fat. M is a deep injury which traverses the skin and goes through the muscle and actually exits the arm on the other side. And that injury is separately designated as a letter in my photographs and documentation, but you can't see that injury in this particular photo. It's on the other side. Part of what's bridging these here is a superficial scratch. This really has nothing to do with the internal track that, of the blade as it injured the soft tissues between the entry here and as it stuck out the skin on the other side. Which you don't see, and I have designated as S. Yeah.
Right, we'll look at that in a moment.
Yeah.
All right, so again, we're looking at M. S, unfortunately, is hard to see, although there is a tab there, a sticker on the far side, but your trajectory rod goes from M through into S.
Yes, and you can see the other end of the rod here, and we use these trajectory rods simply to demonstrate when an injury does pass all the way through the body and when it does so clearly, so that these are inserted when the path through the tissue is already clear, just to demonstrate that for photography purposes.
So based upon what we're seeing, Doctor, did the cutting instrument or knife or whatever was used, did that go from M all the way through, is it a through and through stab?
It is.
What about K? Wound K?
K is longer on the skin than it is deep, so it might be best classified as a cut or a slash, and thus is relatively superficial, did not cause any major underlying injury. And I believe the same is true for this injury here, which is J, which we can just barely see at the edge of the photo there.
Let's move on now to 33L. And there's J.
Yes.
So, again,
J.
we're looking at a through and through.
We are, and it's very superficial, this one. The other one, you can see S here now without the trajectory rod through it. That's M was over here, and the trajectory rod passed through here to S. Here we see a very superficial wound that was just long and deep enough to have a small exit over here on the edge, if you will, of the wrist area, as opposed to the middle of the forearm here.
These two injuries that we looked at, M into S and then J, Are you able to say whether those are defensive wounds because they're on the victim's arm?
I think they're consistent with using the arms for self-defense during a knife assault. Some might characterize that then as being a defensive wound.
Now we're going to look at Ms. Tower's right hand. And what do we see here?
So this is the palm of her right hand, and this photograph was taken as the body was received by us, so before any cleaning was done. But even so, you can see the clear stab wound on the thumb side of the palm here next to the base of the thumb.
Okay, and moving to the next photograph, and they're related. So we see at the base of the thumb, and then we see at the base of the thumb on the opposite side of the hand. So what's going on with these two?
Yes, so this is an entrance and exit pair as we identified previously. The stab wound essentially passes through the soft tissue of the side of the hand at the base of the thumb and injured the underlying tissues, but no bone or anything more major than that.
Let's look at the left arm. This is Exhibit 33O. And we're looking at, is this a superficial wound, doctor?
It is. It passes, this cut wound goes just a little bit deeper than the subcutaneous fat there, but does not involve any deeper structures and certainly no major vessels or vital organs.
33P.
P shows us two injuries. H, which is slashing type or deep cutting injury that again involves only the subcutaneous fat. And I is a penetrating injury that involves the skin and soft tissues, but does not go particularly deep and does not cause any additional major injury.
And is this Mrs. Tower's left leg? Back of the left leg?
Correct.
Now I want to talk about Jennifer Tower's larynx. It appears that you removed both larynx from each victim. So what did you find that was distinctive about Jennifer Tower's larynx?
She did have a single stab perforation of the larynx here, but there were no deeper injuries. There were no stabs throughout the area through which the air actually passes. So the structures here were all intact. That's why the only photo I took here, I did not include that propping stick so that you could open up and see what was internal. There were no findings that were significant in here, just this one superficial perforation into the larynx. And I think it's worth noting that this is the inner surface of the upper portion of the larynx here. So the stab wound came from the outside through this in, but didn't go any deeper.
Doctor, after performing the autopsy on Jennifer Towers, were you able to form an opinion as to the cause of Jennifer Towers' death?
I was, yes.
What is and was your opinion?
Similar to Mr. Tower, I determined her cause of death to be perforations of multiple small and large blood vessels, including the carotid artery and jugular vein, due to multiple stab wounds.
And do you have an opinion as to the manner of Jennifer Tower's death?
Yes.
What is your opinion, doctor?
My opinion was and remains that the manner of death is homicide.
You have a moment. nothing further at this time, Doctor. Thank you.
You're welcome.
Are those the photos and evidence, Ms. Fragley, that you have?
I beg your pardon? Yes, they do.
Can we return those to the clerk? All right, defense, cross when you're ready.
Thank you, Aaron. Good afternoon, doctor. How are you?
Good afternoon. I'm fine. How are you, sir?
Wonderful. So we noticed in some of those pictures there was some redness and different coloring. Is that from the pooling from being in the prone position for a long period of time?
There is lividity that was present in those photos. Lividity is the pooling of blood that occurs after death, and it did occur because the bodies were in that position for a period of time.
Okay, so the redness that was seen as like different color skin colors doesn't necessarily denote anything other than the pooling. Is that a fair statement?
It is.
Okay. As the same with if somebody is laying face down after death, you would expect the same pooling in the face area, correct?
Yes.
And could that make it appear as if there was bruising there?
It could, yes.
So all of the different areas where we see redness as opposed to the white, that would be indications of pooling and lividity and where blood is settling, correct?
Almost everywhere. I'm trying to remember if there were any pink or red contusions anywhere in the bodies. There might have been a little bit of red contusion in one of the cases, but I think everywhere that I saw contusion, it was blue, and we talked about that.
Got it. So when we're talking about the different injuries, you say it's not necessarily from different implements just because they look different. If they're bigger, longer, things like that, that doesn't denote anything as far as different implements, correct?
That's correct.
All right. And I would suggest that would you say the vast majority of these injuries you would describe as superficial?
I would describe them at least as not deep enough to be life-threatening.
Sure. And I think the majority of the wounds that you talked about said that they were soft tissue wounds, correct?
That's right.
And those would not be lethal in and of themselves.
Correct.
When you're talking about the cause of death, that is different than the mechanism of death, correct?
Yes.
Okay.
Sometimes they can be very closely related. Sometimes they're a little more distant, but yes.
So in this instance, you said the cause of death was multiple perforations, correct?
Yes.
In Mr. Tower's case, there were multiple perforations that were caused by stab wounds. That's the cause of death, correct?
Yes.
Would the mechanism of death in that case be essentially lowering the blood pressure to make the heart stop? Would that be kind of the mechanism by which the body would work?
Yes.
Okay. Now, obviously, if there are lots of punctures into the lung cavity, that can create some other issues as far as lack of pressure and lungs not being able to expand. Did you see that in this particular case?
I didn't.
Okay. So essentially, it's the getting of the artery in the neck that is the majority of the problem, correct?
I think those were the most severe of the injuries by far in both cases.
Okay.
But I didn't want to rule out the cumulative effect of blood loss from all of injuries, and thus that's why I didn't single those out specifically, but included the other injuries as well.
And I know that I'm kind of conflating both of them, but it sounds like the cause of death for both of these individuals is essentially the same, the loss of blood from multiple perforations from stab wounds, correct?
Yes.
And that would be a similar mechanism of death as well, correct?
Yes.
All right. Now we're talking about manner of death being homicide. You would agree with me that there's only a finite number of manners of death that you could qualify it as, correct?
There are only 5, yes.
Okay, and that would be homicide, correct?
Yes.
Suicide?
Yes.
Natural death?
Correct.
Unknown? Meaning you don't know what the manner of death is, correct?
We use undetermined, but
Determined.
more or less the same thing, yes.
And what's the 5th one? You said there were 5. What's the 5th one?
Homicide.
We started with homicide.
Okay.
Suicide, correct?
Yes.
That's 2.
Natural, undetermined, and accident.
Accident. Thank you so much. All right. So when we're talking about those things, you're not making a determination as far as legally this is what qualifies. That's more of an analysis to determine across the state how many homicides occur, how many suicides occur, things along those lines, correct?
That's right.
All right. Nothing further, Your Honor.
Any redirect?
First of all, Doctor, on cross-examination, there was a question about whether either of the victim has sustained any other injuries aside from the knife wounds. Did Mr. Tower have an injury to his head?
Yes.
Can you tell us what that injury consisted of, please?
So one of the injuries that we described was the lettered injury O, and that had, it was more of a scrape as opposed to a penetrating blade wound. Let me make sure I'm referring to any other minor head injury that I might have described. In addition to that injury, I believe we saw these in one of the photos, but I can't remember if they were specifically questioned about. There were 2 small abraded contusions on the head, one to the side of the left eye and one in the region of the chin. They were pretty minor, not necessarily very easy to see.
Yes, I did not question you on those, but I am questioning on now. So in addition to those additional injuries to Mr. Tower's head, I want to ask you this final question. If a defendant admitted to killing his parents, would that be consistent with your finding of homicide?
Yes.
Thank you. Nothing else.
The witness free to step down?
He is.
Nothing further.
All right, you may step down now.
Thank you, Your Honor.
Folks, in just a moment, we're going to take about a 10 or 15-minute break, okay? So if you can leave your notepads face down, writing implements on top. Don't discuss anything related to your jury service during our break, and we'll bring you back shortly, okay? Everybody please stand. Jurors exiting. Everybody may be seated. Apparently there's something else we need to cover. Let's have the attorneys come forward. It has to be done now? Okay. You want it done now? Okay. All right, folks, there is a stipulation as to the identity of the victim/decedents. Stipulation meaning both the state and the defense have agreed to that, so it is something for you to consider as a fact. I'll sign it. It will go back with you. Let's see, today's the 13th, and I'll read it to you. It is hereby stipulated by and between the parties of this action that the identity of victim/decedent number 1 in this case is Robert James Tower, white male, date of birth August 15th, 1974, a human being, and that the jury in the trial of the above listed cause may be advised of this stipulated fact. It is hereby stipulated by and between the parties of this action that the identity of victim/decedent number 2, in this case, is Jennifer Christine Tower, white female, date of birth February 8, 1972, a human being, and that the jury in the trial of the above listed cause may be advised of this stipulated fact. All right, let's take our 15-minute break. Everybody please stand, jurors exiting. All right, doctor, here you go.
Thank you, Your Honor.
All right, State, are you prepared to rest in front of the jury after our break?
Yes.
Okay. Mr. Gilman, any motions from the defense?
Your Honor, I think that at this point, taking the evidence in the light most favorable to the state, it's a factual determination as far as premeditation is concerned, so I do not have any legal motions to make at this point.
Yes, I'll find that the evidence presented in the form of the witnesses, the photographs, the physical evidence, the video of the defendant's statements to law enforcement, of the medical examiner, that there is sufficient evidence in a light most favorable to the state for all 3 of the crimes charged. 2 counts of murder in the first degree and fleeing to elude law enforcement with lights and sirens. So I'll deny the motion for judgment of acquittal as to all 3 counts. This will go to the jury. Mr. Gilman, do you have any evidence that you intend to present during the defense?
Your Honor, I've spoken with Mr. Tower about it. He's indicated his desire to testify.
Okay.
That is against advice of counsel.
Okay. Everybody may be seated, by the way. Any objection to me speaking to Mr. Tower briefly
No, Your Honor.
about the legal concept of this? All right, Mr. Tower, can you please raise your right hand, sir? You can remain seated. Do you swear or affirm that your testimony will be the truth?
I swear.
You can put your hand down. Please tell me your name.
Dima, James Tower.
Mr. Tower, I'm going to speak to you for just a minute, and I want to make sure you understand that at no time am I asking you to divulge any specific statements between you and Mr. Gilman. Those are protected by the attorney-client privilege, and I'm not asking for any specific conversations that you have. Do you understand? If you think that I am, let Mr. Gilman know or tell me you're unsure of my question, because that's not what I'm intending to ask, okay? Yes?
Yes.
Okay. The state has just rested their case in chief. They will in just a moment when we bring the jurors back in. They're going to rest on the record. So at this time in the trial, it's the opportunity for the defense, if they wish, to call witnesses and produce evidence. Do you understand that?
I do.
You might recall during the jury selection process, I talked to the jury. I spent a considerable amount of time covering this with them. That the burden in a criminal case is solely on the state of Florida, the state attorney, and that there is no burden on the defense. Do you understand that? In fact, you might recall I read to the jurors that the defense does not have to present any evidence or prove anything. In fact, I gave the jurors the example that you and Mr. Gilman didn't even have to be present during the trial. Do you recall that, Mr. Tower?
I recall.
Do you have any questions about that?
No.
Okay. Mr. Gilman has indicated that he doesn't have any attorneys or evidence to produce at this point, other than perhaps you. Is that your understanding as well?
Yes.
Okay. So now would be the time in the trial, if you wish to testify, that you would take the stand. Do you understand? Now, I also covered this, Mr. Tower, during jury selection. That choice as to whether or not you testify is solely or completely your choice. In other words, Mr. Gilman cannot make that choice for you. In fact, nobody can make that choice for you. Do you understand?
I do.
Mr. Gilman is a very experienced attorney. His job is to counsel you. He can give you his opinion, his advice, talk to you about the evidence that's been presented. but Mr. Gilman cannot make the decision as to whether or not you testify. That's solely your choice. Do you understand?
I do.
If you choose to testify, there would be a jury instruction. In fact, we've already discussed that. You might recall this morning at 9 when we went over our jury instructions. That instruction would tell the jurors that you have become a witness, that they should consider your testimony just like any other witness. For example, there's a jury instruction 3.9 that says, in addition to your common sense, you should consider the following factors when considering the testimony or credibility of a witness. Did the witness have some interest in how the case should be decided? Did the witness say something in court that's different than a statement they had previously made? Was the witness honest and straightforward in answering the attorney's questions? Does the witness's testimony agree or disagree with the other evidence in the case? Has the witness ever been convicted of a felony or a crime of dishonesty? These are just some of the tools that jurors will be using to determine credibility of witnesses, and if you choose to testify, they would use the same tools as it relates to you. Do you understand that, Mr. Tower? Do you have any questions about that?
No.
In fact, if you choose to become a witness, you'll be called just like what we'll do is we'll put, I believe that you have shackles on your ankles. Is that right?
Right now, yes.
All right, so what we would do is, do we have the sergeant here?
Well, Your Honor, we can do the same as we did.
All right, let's call the sergeant down. We'll figure that out. What we would probably do is have you up at the witness stand so the jurors couldn't see that you're shackled. In fact, they wouldn't be able to see that you're shackled. I see that in this courtroom, the jurors are in front of the witness stand. You would be sworn in by the clerk, just like every other witness. Mr. Gilman would have an opportunity to ask questions first. Your attorney, they would have to be open-ended questions. When Mr. Gilman is finished, the state attorney, one of the two prosecutors, would come up and they'd be able to ask you leading questions. We refer to that as a cross-examination. When the state is completed, Mr. Gilman would have another opportunity to come back. That's called a redirect. And that's what's happened with almost every witness so far. The same would apply to you. Do you understand that, Mr. Tower? Do you have any questions about the procedure or how your testimony would be treated the same as any other witness?
No.
State, are there any prior felonies or crimes of dishonesty?
Or not.
Okay. Do you have any questions about any of the laws that apply if you choose to become a witness?
No, I do not.
If you choose not to become a witness, that's a constitutional right you have. You might recall I spent a considerable time Monday, Mr. Tower, talking to the jurors about that. I explained to them there's many reasons why one might choose not to testify, public speaking being fear number 1, death 2. And I explained to them that it can't matter, that if you chose not to testify, that's something that the jurors could not take into consideration. In fact, the jury instruction would say that. It would say that Mr. Tower has chosen not to become a witness. You cannot consider that decision as any consciousness of guilt. In fact, the jury will be told they can't consider that in any manner whatsoever. Do you understand that?
Yeah.
Do you have any questions about the laws that would apply if you choose not to become a witness?
No.
Have you had an opportunity, not what you said, but have you had an opportunity to talk to your lawyer and ask him questions before you reach your decision as to whether or not you will testify?
I have.
Do you need any additional time, Mr. Tower, to talk to your attorney before you tell me what your decision is?
Do not.
Okay. And have you reached a decision?
Yes.
And what is your decision?
I want to testify.
Okay. Has anybody pressured you or forced you in order to get you to testify?
No.
Are you doing this freely and voluntarily?
Yes.
Do you have a clear mind as you're entering into your decision today?
Yes.
Are you taking any medication right now while you're at the jail?
No.
Do you have any questions of the court, anything related to the laws surrounding your decision?
No.
Or your testimony?
No.
Okay. I'll find that the defendant has made a freely and voluntarily and knowing decision to become a witness in the case. So let's take a 10-minute break. What we'll do, any objection, Mr. Gilman, state to having Mr. Tower on the stand when the jurors come back in, and you can call him?
No, Your Honor.
No
Okay.
objection.
And then, so Mr. Tower, what we'll do is, when we come back from a break, we're gonna have you on the stand. Again, the purpose is so that they don't see the shackles on your feet, okay? And we'll have you standing in when the jurors come in. in front of the chair so the jurors can't see it. What will happen is I'll have everybody seated. The state will rest on the record in front of the jury. I'll then turn to Mr. Gilman, your lawyer. He's going to call you as a witness. At that time, I'm going to ask you to stand from your chair. Do so carefully not to make noise with the shackles, okay? You'll stand at that moment, face the clerk. Our clerk, Emily, is going to swear you in. She'll ask you to raise your right hand. You'll be sworn in. You'll have a seat. When your testimony is completed, give me a moment. I'm not going to have you walk back down to your table. Again, we don't want them to know you're in custody and that you're shackled. We'll take a break as soon as your testimony is done. I'll send the jurors out and we'll return you to the table, okay? Unless, yes, let's do it that way, because then we'll find out if the state has rebuttal, et cetera, okay? Let's take a 10-minute break. We'll come back with the testimony of the defendant. We'll have him on the stand. State, makes you please call any and all witnesses. I want to finish the evidence portion of the trial today, okay?
Yes.
All right, 10-minute break. 2:50, we'll start at 3 with the defendant on the stand. sent the updated jury instructions to
I will
Jennifer?
send that right now.
And you can make the changes now, removing defendant not testifying and including that paragraph, defendant becoming a witness. All right, let's practice, Mr. Tower. Practice getting up once you fix the chair.
One down there.
All right, does that work? All right, practice getting up without making noise with your feet. Okay.
So right now, when you start talking, just pull it closer to you.
Okay, you got it?
Yes.
Okay, both sides ready to proceed?
Yes.
Yes,
All right,
Your
let's
Honor.
bring the jurors in. So, Ms. Frablich, you're gonna rest on the record. I'll turn to Mr. Gilman, and you can call your client, Mr. Tower, as a witness. Let's bring the jurors in.
All rise, jurors enter.
All right, everybody may be seated. All right, state.
Your Honor, the state is resting its case in chief.
All right, the state has rested their case in chief, so I'll turn to the defense. Mr. Gilman.
The defense calls Dima Tower.
All right, Mr. Tower, can you please stand and face the clerk? Madam Clerk, can you swear in the witness?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
You may be seated. Mr. Gilman, when you're ready.
Can you just move up a little closer and make sure you're talking in the microphone there, okay? Can you please tell us your name?
Dima James Tower.
And Mr. Tower, how old are you?
I'm 24.
Okay, and where, I noticed you have an accent. Where were you born?
I was born in Ukraine,
What part of Ukraine?
in far east part, Luhansk. That is borders with Russia.
And when did you come to live in the United States?
I came in, believe I came in 2015.
So you were living in Ukraine in February of 2014 when there was an incursion into Crimea? I use a lot of big words there, I'm sorry. Were you living in Ukraine in February of 2014?
Yes.
Okay. And where were you living when you were in Ukraine, before you came to the United States? Where were you living? Like what type of house?
Before the orphanage?
No, I was talking about the orphanage. Tell me about that. What type of place was that?
Should I talk about my life before the orphanage, or?
We will, sure. How did you end up getting to an orphanage?
I'm gonna object to all this.
Yeah, I mean, I'll allow brief background, very, very brief, so let's not spend too much time. Okay?
Sure. And Your Honor, actually, if we could approach briefly.
You may.
So how old were you when your mother passed away?
Well, my mother passed away. You know, I would like to talk about, before I would start about talking about my life before my mother passed away.
I understand that.
You know,
The issue that is that I'm hoping that you can respond to the questions.
Yeah, I can respond to the questions,
Sure.
but
Okay, so your mother, how old were you when your mother passed away?
somewhere between 6, 7, or 8.
Okay,
I was thinking about this somewhere between those years.
Okay.
But, I mean, if maybe I can give a little bit of my personal background or something.
Mr. Tower, the way it's going to work the same with all witnesses. You need to listen to the question and then answer only the question that's been asked of you, okay?
Well, it's important that.
It may be important, but you need to follow the rules in a courtroom, okay? Please ask your next question.
Sure. Were you just living only with your mom when she passed?
Yes.
Okay.
I was.
And then who did you go to live with after that?
I went to live with my brother.
Okay. How long did that last for?
Maybe a couple months, so.
Okay. And then where did you go?
I went to my uncle's house.
Okay. How long did that last for?
A couple months.
And you eventually end up in the foster care system in Ukraine, correct?
Objection, leading.
Yeah, I was in 2 orphanage for foster care, orphanages, whatever they call that. The first one I was in before the war, and then
Objection,
I was.
non-responsive.
Overruled. I think he's trying to give a time frame of when he was in the orphanage. You can answer the question.
I was in the first orphanage in that same region I was born in, the same side of Ukraine. And then when the war started, we were moved to another part of Ukraine, which is somewhere close to the sea.
And was it around that time that you met the Towers, that they came over to meet you?
Yes, I met him at, I believe it was end of summer of 2013. I met him. Well, I actually met him over here after I was sent to visit for a month in the States. I flew in and met him at the airport.
Was that the first time that you had met them?
That was for the first time, yes.
And how long after that do you come to this country?
Well, I also came for the second visit. That summer of 2014, I came for the second visit to meet the rest of the family.
And then you come to live permanently when? In 2015?
Well, I was adopted right before the 2015. I was adopted that winter. and we, I came to live here in 2015 years.
Okay. Did you go to school here in Sarasota County?
The questions that you're asking me are very complicated, and cannot be simply answered, but I'm forced to simply answer the questions, which cannot, for no right reason, can be answered simply. These are not simple questions.
Your Honor, I object to the editorializing by this witness. Other witnesses are not allowed to have this kind of conversation with counsel.
Let's try not to have speaking objections, Counselor. I'll sustain the objection as non-responsive. Please move on, Mr. Gilman.
Do you remember talking to law enforcement in this case and telling them that you went to Northport High School for a little while?
Yeah, I went to, right after I was adopted, I went to the school in Northport, Woodland Middle School. And then after I did a half a year in that, I enrolled in Northport High School.
Okay.
Which I dropped out of in 10th grade.
Okay. And did you know any English before you came to the United States?
No.
How did you learn English?
By conversating here and there, small talk.
All right. And how long did you live with the Towers prior to, either graduating high school or moving out?
Again, this is a complicated question, and
Objection to narrative.
the answer, it can be very long because I moved in, I moved out.
Objection to narrative.
I'm going to sustain the objection as non-responsive.
Okay. You said you dropped out after 10th grade. Did you move out after that?
No, I stayed, but I didn't really move out on my own. It's just too many family issues.
Okay. And you were not living with them. When did you move back in with them prior to August the 31st of 2023?
I don't understand the question.
So in August of 2023, which is the incident that we're talking about, how long prior to that were you back living with the house? Because I know you had just moved back there, correct?
Well, yeah, I assumed that
Do you need a moment, Mr. Tower?
Remember the jurors, let's take a break. Please leave your notepads face down, writing info numbers on top. Please don't discuss anything related to your jurors. Everybody stand, jurors exiting. Mr. Gibbon, why don't you spend a moment with your client? We can't tolerate this kind of behavior here in the courtroom. I've already spoken to your client about it. So let's take a 5-minute break. Let's let the defense have an opportunity to talk to the defendant to see if he can go forward on the stand. okay and able to continue?
Yes.
Okay. You understand why we took the break, right? I can't have that, that kind of show of emotion in front of the jury and that applies to you and every other witness. You might recall I even said that about the folks in the audience. Do you recall that, Mr. Tower?
I do.
Okay, are you able to move forward in that
I am.
direction? Okay. Also, Mr. Tower, the way a jury trial works is the attorneys, their job is to ask questions, and your role as a witness is to answer the questions that are asked of you. Do you understand?
I understand.
Okay. Mr. Gilman, anything we have to discuss before we move forward?
No, Your Honor.
You had an opportunity to talk to Mr. Tower about
I
the
did.
procedure and how we'll move forward?
I did.
All right, anything else to discuss with the state?
No, Your Honor.
All right, both sides ready to bring the jurors back in?
Yes, Your Honor.
All right, let's bring the jury back in, please. All right, everybody may be seated. Welcome back, members of the jury. All right, Mr. Gilman, when you're ready, please continue.
All right. And Mr. Tower, I want to focus you on when you sat down and talked with the police down there in Venice. Do you remember that?
I do.
Okay. Was that the first time that you had ever had that kind of encounter with police?
Yes.
How'd that make you feel?
Awkward. Made me feel awkward.
Hold on.
Hold on, one moment. I'll overrule the objection.
Okay. Why would you say it makes you feel awkward?
Because I'm uncomfortable talking because I had many miscommunication and or not enough communication or misunderstanding with my adoptive parents. So I grew up into not knowing how to talk.
Objection, non-responsive.
Overruled. It was completing the answer. You may continue, Mr. Gilman.
So when you were talking with the police, did you understand everything that they were asking you?
I did.
Did you feel like you answered appropriately given that you were uncomfortable?
No.
Okay. Do you remember talking with them about multiple times having thoughts of killing your parents?
Yeah, I only had those thoughts a couple times.
Okay. Did you ever have a plan in place to make that happen?
No, I did not.
Okay. I don't think I have anything further, Judge.
State cross-examination when you're ready.
Are you going to look me in the eye, Mr. Tower? Guess not. So you said you didn't think about killing your parents.
I did not plan on it.
Mr. Tower,
It was not premeditated.
Mr. Tower, when I ask you a question, you can answer, but not until then. You pulled out a sharp knife and you walked into your parents' bedroom, didn't you?
Yes.
Okay. What were you thinking about between the time you took that sharp knife, walked into your parents' bedroom, and started to stab your father in the dark?
I wasn't thinking anything.
You weren't thinking anything.
What is there to think?
I don't know. Your parents were sound asleep, weren't they?
I don't know.
Was your father awake when you started to stab him?
It was pitch black.
You picked up a knife from the kitchen and you cowardly went into your...
Argumentative.
Were your parents awake?
I don't know if they were awake. I already answered it. She asked me a second time.
What did you say?
You asked me a second time the same question.
What did your father say after you stabbed him?
What the hell are you doing?
And then what happened? Did you stab him again?
Yes.
Okay, what were you thinking about between the first stab and the second stab?
There's nothing to think.
Nothing to think.
What am I supposed to think then?
Listen to me, you don't, there was nothing to think, that's your answer, all right. So, you're telling me that as a human being, you walked into your father's bedroom with your mother sleeping next to him. The parents that brought you over here.
Objection, argumentative, compound question.
These people were not my parents.
Hold on. I'm going to overrule the objection. It's a bit compoundish, but I'm going to allow it. You may continue with your question.
Thank you. The parents that brought you over here to this country, and you weren't thinking anything.
These people were not my parents. There's a lot went on that changed our relationship.
That's not my question. My question is, are you telling this jury that you won't even look in the eye that the people who brought you over here and gave you a home, that you were stabbing them and you didn't think anything of it? Is that what you're saying?
Answer's too complicated for you.
No, it's not a complicated answer. It's a yes or it's a no.
It's not. It's a complicated answer.
Tower, you told the detectives that you were a nobody from nowhere, didn't you?
When I was talking to detectives, I was not in my completely right state of mind.
Mr. Tower, did you tell the detectives that you were a nobody from nowhere?
I just answered your question.
No, you didn't.
I said I was not in my right state of mind when I was talking to detectives. It just went on a lot, you know.
Let the jury recall what they heard.
Objection, argumentative.
I was under the influence of alcohol also.
I'll sustain that it's unresponsive. He's not answering your question.
Your parents.
They were not my parents, unfortunately.
Sir, you cannot interrupt the attorney. Wait for them to finish their question, and then you can answer the question asked of you, okay? Please ask your question.
Mr. Tower, the people that brought you over here, they gave you an opportunity to be a somebody from somewhere, didn't they?
It depends on their parenting.
What?
It depends on their parenting, how you raise your children.
Depends on the what?
You don't even know what I'm talking about.
No,
Have you ever been a mother of children?
After you stabbed your father to death, you walked outside with a knife in your hand because Jennifer was outdoors, wasn't she?
I was temporarily insane.
Sir, can you please sit
All right. When you walked out of the house after you killed your father, did you carry the knife with you to lead Jennifer back in?
I did.
You did or did not? I can't
I
understand.
said I did.
You did. You took the knife with you to go out and find the person that adopted you.
Yes, I was temporarily insane, as I said.
Temporarily insane.
Yes.
Uh-huh.
Members of the jury, I'm going to ask that you strike that last response. There is no insanity defense. There is no evidence presented in this trial to insanity. So I will just order that you not receive that answer. It's irrelevant, not permissible during this trial. Okay? Please ask your next question.
Thank you. Were you thinking about killing your mother when you went outside with the knife and led her back in?
What do you mean by thinking?
Did your parents buy you a car?
Objection outside the scope.
Overruled.
What does has to do with this?
Did your parents buy you a car? Answer my question.
Well, I know where your question is. I know.
Answer
I don't
my
understand.
question,
I don't
Mr.
understand your
Tower.
question. I don't understand it.
Did your parents buy you a car?
I don't understand this question.
Did your parents get you a bank card?
Yes, and I don't understand it.
Are the-
What's the point of this question?
Did your parents get you a bank card?
So?
Did you have a TV in your room?
No. What's the point of these questions?
You told the detectives that you were thinking about killing your parents for the last several days. Isn't that true?
That is not true.
Were you in the courtroom when your recording was played? Mr. Tower,
I was.
were you listening?
I was listening.
And did you hear that you were telling the detectives that you were thinking about that for more than a day?
Again.
You don't remember that?
Again. I did not know what I was saying. Also, I only taught this a couple of times. This was not a constant thought in my head.
Okay, so you thought about it at least a couple times before you did it?
No, I taught it one time, and the second time I taught it, I did it. There was no thinking about it.
You thought about it the first time, and then you put it off. Then you thought about it the second time, and then you went and did it? Is that right?
Correct.
Okay. So when you thought about it the first time, where were you?
Probably in the car somewhere.
Where in the car? Parked in front of your house?
Possibly. Very possibly.
Very possibly.
Well, I don't remember. You asking me a question that happened a long time ago. I don't remember.
Okay. Why did you ask your mother to go back inside the house?
Brought her off the street. I don't know.
Because you wanted to kill her, didn't you? Did you hear the doctor talk about how many times you stabbed your mother, Jennifer Towers, the person that you say is not your mother? How many times did you stab her?
You're talking to someone who has no understanding.
You don't understand that question?
No, you don't understand what you're saying.
How many times did you stab your mother?
I didn't know.
More than once?
And more than once. I don't know how many times.
More than twice?
You've seen it how many times? So we were all in here. You've seen it.
because these members of the jury have a right to hear what you have to say.
Objection, Your Honor.
They don't hear what I say because I'm not allowed to say
Let's
it.
not have an argument between you and the witness, okay? Let's ask your next question, please.
These jurors are not allowed
Did
to
you-
what I have to say.
Hold on. Mr. Tower, you need to wait until the question is finished and then answer the question that's asked of you, okay? Please ask your next question.
Thank you. You told the detectives that you stabbed your mother to death, but not until you finished what you had to say to her. What did you have to say to her that night?
There was a lot went on between the three of us.
What did you say to your mother before you stabbed her to death?
I'm answering your question. You're not listening. There was a lot that went on between the three of us. It wasn't just a parents and a child.
So there was a lot that went on among the three of you, correct?
That's what I just said.
Okay.
That I'm being stopped from talking about.
How old were you when you killed Jennifer and Robbie Tower?
21?
You were a grown man, weren't you?
No, I was not. You don't know the definition of a grown man.
At 21 years old, why didn't you just move out if you didn't like the people that you were living with? Why didn't you just move out?
The age has nothing to do with it.
Mr. Tower, why didn't you just move out if you didn't like the people you were living with?
I did move out a long time ago. I came back.
You went to West Virginia, didn't you?
Before West Virginia, I moved out. I just told you there was a lot that went on between the three of us. That the judge and the state won't let me talk.
Mr. Tower, do you believe in free will?
There's no free will. You know, we're all controlled in the states.
Mr.
Especially.
Tower, answer my question. It's a simple question. Do you believe that people have free will?
The answer, the question is not simple. If you look around, this is bigger than us.
When you went to live in West Virginia, how long were you up there?
I lived other places before West Virginia.
I didn't ask you about that. I asked you how long you lived in West Virginia.
Maybe 9 months, 10 months,
And what were you doing up there?
working.
Who set you up in that place to live in West Virginia?
There was a church that I found. The pastor over there helped me.
You were living with Jennifer's father in West Virginia, weren't you?
That was a long time ago before I went to West Virginia to live on my own.
Please answer
You get
my
it
question.
but you get
Mr.
the
Tower,
questions mixed up.
Mr. Tower, did you live with Jennifer's father in West Virginia?
That was a long time ago. That was not during the time when I went there by myself.
Why did you go to live in West Virginia when you were living with Jennifer's father?
The time that I did go to West Virginia to live with her father was because
Because why?
I'm gonna answer. Let me think about it. We were having fights in the family, and I was gonna visit. I was gonna see him for
Could we
maybe
have
for a
him
couple,
move away
maybe
from
for
the
a couple
microphone
months.
so we can hear?
Maybe for a couple months, I was gonna visit him until I went to Job Corps.
Yeah, who set you up in the Job Corps? Jennifer, didn't she?
What is your point?
Did Jennifer set you up in the Job Corps?
No.
Did Jennifer set you up to live with her father in West Virginia?
No. What is the point of your question?
Remember, you're under oath, Mr. Tower. You're
I know I'm
under
under
oath
oath.
to tell the truth.
You're making no point in your questions. You're forgetting there was
Mr. Tower, you
the
need
father.
to wait for a question to be asked of you and then answer the question, please. Please ask your next question.
You made Jennifer and Robbie's life in their home a living hell, didn't you, Mr. Tower?
Again, there was a lot that went on.
Yes.
Yes, but
Yes.
some adults don't know how to be
Yes.
parents. Yes.
You made their life a living
Yeah,
hell.
no, I didn't. There's some adults don't know how to be parents. You don't know what you're talking about.
In fact,
I came from a harsh environment.
many people come from a harsh
Yeah,
environment,
but
and they don't
gotta
kill
know,
their parents.
you gotta know how to treat those people correctly so they grow up properly.
Yeah, so how do you need to be treated?
I have been treated. It's too late for that. I'm adult now. But you're talking as if you don't know how to be a parent, and you don't know what it takes.
Are you a parent?
No, I'm not a parent. But you're asking me a
You made their life
pointless
a
question.
living hell. In fact, your father told you that you were destroying his marriage
If I
to
made
his wife. Isn't it true?
if I made their life a
Mr.
living hell,
Folks,
that's probably
hold
had
on,
something to
hold
do
on.
with them.
The two of you are just talking over each
No,
other.
he's
Ms.
refusing to
Fragley,
answer.
You're asking a question, he begins to answer, and then you add to your question. Mr. Tower, when she's speaking, you then begin to answer. And what's happening is none of us are catching the question nor the answer. So let's please follow the procedure that we've done all throughout the trial. Let's please do a question, then we'll do a pause, and then the answer. Mr. Tower, I need you to answer the question and not ad-lib and add to it, okay, sir? Please ask your next question, Ms. Fragley.
Did your father tell you that you were disrupting his marriage to Jennifer Tower, his wife?
Jennifer told me that before the adoption, that in the beginning,
He's not,
Rob,
not responding.
I'm responding. Rob did not want to adopt at all, and then he wanted to adopt a daughter, and then finally he agreed to adopt a son. So he didn't really want to adopt to begin with.
Mr. Tower, there was no question related to wanting to adopt other children. The question was calling for a yes or no response. If
Well,
you
he
could
didn't
please-
really want to adopt me, is what I'm saying.
Mr. Tower, if you can please listen to the question and answer yes or no. Please ask the question again.
Thank you. Did your father tell you that you were destroying his marriage to Jennifer?
I was not destroying his marriage to
That's not
Jennifer.
the question, sir. The question was, did your father tell you that? Did your father tell you that, yes or no?
What do you want me to say? He doesn't know how to love his wife. What do you want me to say?
Right, I'll sustain the objection as unresponsive. He's unable to answer. Please move on to your next question.
Who paid for your flights in 2013 and 2014?
As stated, at some point, I'm going to cut off all these questions about perhaps benevolent acts. You can go a bit further, but let's start to move on, okay? I'll overrule the objection. You may finish your question.
Yes. Who paid for your flights to the United States in 2013 and 2014?
This question is pointless, but however, the company who provided who had something to do with adoption did. And I don't understand what's the point of this question either.
Why did you drop out of high school?
Because I was being brainwashed, as the rest of the children are.
You dropped out of high school because you were on the verge of getting expelled, weren't you, Mr. Tower?
What expelled? Do you even know what they teach in schools? What are you talking
Mr.
about?
Tower, answer my question.
I'm answering your question. You don't know what you're saying. These schools today, they don't teach anything the kids should know. And the schools are not for everyone.
Mr. Tower, you dropped out of high school because you were on the verge of getting expelled from high school.
No, I wasn't. I'm telling you that. You ever been to school? You know that schools don't teach kids proper education.
Mr. Tower, stop talking.
I'm talking because you don't know what you're talking about.
All right, let's move on to the next question. His answer was no. Please move on to your next question.
In fact, you were about to get expelled because you were fighting with other children in the school and on the bus, weren't you, Mr. Tower?
No, I wasn't. I just told you what happened.
How old were you when you dropped out of high school?
I don't remember.
You don't remember. How old were you when you were in 10th grade?
I said I don't remember.
When you were sitting out in your car before you went into the house on the night of August 31st, did you decide to kill your parents before you walked in?
Yes.
I don't have anything else. Thank you, Your Honor.
You redirect, Mr. Gilman?
Nothing, Your Honor.
All right, we're going to take a short break, 5-minute break. Please leave your notepads turned over, face down, writing implements on top. Everybody, please stand. Jurors are exiting. All right, everybody may be seated. Mr. Tower, you can return to your table next to your lawyer, sir. Mr. Gilman, any additional evidence, sir?
No, Your Honor.
All right, state any rebuttal witnesses.
No, Your Honor.
Okay. So what we can do is we can bring the jurors back in. Mr. Gilman, you can rest on the record. Is that right, sir?
Yes, Your Honor.
All right, we'll send the jurors home. It's 3:53. We'll have a brief discussion on jury instructions, and then we'll head home for the night. We'll start at 9 o'clock. Does that work for both sides?
Yes, Your Honor.
9 o'clock, I'll read the jury instructions, and then we'll go straight into closings. We'll provide lunch for the jurors so they can begin deliberating right away, okay?
Yes, Your Honor.
All right, let's get the jurors in and out. Deputy Carl, can you bring the jurors back in? Welcome back, members of the jury. Everybody may be seated. Mr. Gilman.
At this time, the defense rests, Your Honor.
Members of the jury, both the state and the defense have rested their cases. So what your job is done for the day. We're going to do a little bit of work here in the courtroom. We're going to start back up tomorrow at 9 o'clock. Let's start at 9 o'clock. Does that work for all our jurors? Yes? We'll bring you in. I'm going to hand out to you the jury instructions. It's a package of the law that applies to the case. I'm going to read that to you. And then as soon as I'm done reading the law, the attorneys will make their closing arguments. We'll send you in to deliberate with lunch, and we'll await your verdict, okay? So have a nice evening. Again, don't watch any news. Don't read any articles, papers, blogs, anything related to this trial, we need you to come back in the same way that you are today. Leave your writing implements, notepads face down. Make sure you take all your belongings. Have a nice evening. We'll see you tomorrow, folks. Everybody, please stand. Jurors exiting. Hey, Jen? Yeah. Did you get an updated email with the jury instructions? I did. Can you bring down just one packet for me quickly? Thank you. Folks, let's take another look at the jury instructions before we adjourn. Other than that, anything else we need to talk from the state? No, Your Honor. Anything from the defense?
No, Your Honor.
Okay. Folks in the audience, we're just going to go over the jury instructions now. It's not very exciting, really. You're welcome to stay. You're welcome to leave. It'll probably be about 15 or 20 minutes, and then we're going to adjourn for the day. Ms. Whipple, you have them up in front of you?
Oh, give me 1 second.
And did you send those to Mr. Gilman?
I have them in front of me.
You're able to pull them up too?
I have them
great.
in front of me, yes, Your Honor.
Great. I just need them in front of me.
Yeah, that's easy.
Thank you, Jen. No. Okay. If you can call and not cancel. Keep it on. Is that what it was? I thought I said you would call and let them know.
Okay.
Thank you.
Not cancel.
Correct. All right, I have them in front of me. Can we proceed?
Absolutely, Your Honor.
Okay. Introduction and final instructions. Any objection?
No objection.
Statement of charges. Any objection?
No objection.
And again, these are ones that will really, let's remind ourselves, we already went over these. I'm going to make sure I look to see based on the additional evidence. We had the FDLE expert, Dr. Vega, and Mr. Tower, who testified. All right, we have introduction to homicide. That's legally accurate. We have
No objection.
count 1, first-degree murder.
No objection.
Count 2. When I was reading the stipulation,
They were swapped.
They were swapped in the stipulation. So I don't know if you want to point that out to the jury or not, but I don't think obviously that will be confusing. But in the stipulation, you identified Jennifer Tower as number 2 and Robbie Tower as 1, but on the on your counts, they're the opposite, okay?
Yes.
All right, count 2, we have murder in the first degree. Those are legally accurate. We have fleeing to elude, law enforcement. Any objection by either side?
No, Your Honor.
All right, lesser included crimes to count 1, first-degree murder. We have murder in the second degree and manslaughter, both sides in agreement.
Yes, sir.
Yes, Your Honor.
All right, I mentioned it. I thought it was appropriate to bring it in front of the jury. It was completely improper for the defendant to make the statement that he was insane. There is no defense raised. There was no designation of insanity. I don't know where the defendant got that from. I hope he wasn't doing that in an intention to intentionally mislead the jury. But of course, neither side is permitted to make any argument, reference that, or any discussion in front of the jury related to that type of defense. Both sides understand?
Yes, Your Honor.
All right, we have murder in the second degree. The lesser included with the count 1, victim Jennifer Tower. And then we have manslaughter next, victim Jennifer Tower. Lesser included for count 2, murder in the second degree, victim Robbie Tower, and then manslaughter for Robbie Tower. Both sides in agreement?
Yes, Your Honor, no objection.
All right, the state has updated the 3.7 plea of not guilty, reasonable doubt instruction as I requested earlier this morning. Any instruction now? Any objection now?
No, Your Honor.
3.9, weighing the evidence. We agreed to 1 through 5. Do any of the others apply?
No, Your Honor.
No.
All right, the only one I thought maybe would be any statements given in court. That might be inconsistent with previous statements, but neither side are requesting that. Is that correct? No. Okay. We have the defendant becoming a witness. That's appropriate. Mr. Tower did testify. Any objection to this instruction as it is?
No, Your Honor.
No, Your Honor.
All right, 3.9B, defendant's statement. Ms. Freiberg, this is why I overruled your objection as to what he was feeling or thinking at the time he gave the statement to law enforcement. I think that's something that jurors are able to consider. So any objection to 3.9B?
No, Your Honor.
No, sir.
3.10, rules for deliberation. That's legally accurate. Cautionary instruction. Single defendant, multiple counts. They took out the information part, which I ordered, and the plural on documents. It's legally accurate now from my perspective. Any objection?
No, Your Honor.
No.
All right, we have the verdict instruction and the verdict form. It has the defendant's name, case number. Count 1 has A, guilty as charged. B, murder in the second degree, a lesser included. C, manslaughter, lesser included. D, not guilty. Again, guilty, not guilty are not italicized, not capitalized. There's nothing drawing any attention to any one of these options. They're perfectly aligned. Count 2, the same applies for count 2. Count 3, same thing. Guilty, not italicized. Nothing's in any way uniquely or highlighted in any way. We have no lessers. Both sides agreed. As to count 3, the fleeing to elude, we have the month and place for the foreperson to date and sign it. Lastly, submitting case to jury, we discussed as legally accurate. Any objection to the instructions as they currently are?
No, Your Honor.
Yeah, I think they're legally accurate, comprehensive, and appropriate in this case. So I'm going to make copies for all the jurors. Are you folks able to make your own copies for the
Yes, Your
evening
Honor.
so you can prepare?
Absolutely.
All right, I'll have a copy on your desk in the morning, just so you have exactly the same copy from my stack, but you have a working copy so you can prepare this evening. All right, Mr. Gilman, any renewed motions for judgment of acquittal now that the defense has put on a witness?
No, Your Honor.
All right, I'll deny the renewed motion for, if there was one. I'll find that there is sufficient evidence for the jury to find the defendant guilty as charged based on the evidence presented and even in light of the defendant now taking the stand. Folks, have a nice evening. If you can just be ready to start up at 9 o'clock tomorrow morning, okay?
Sir.
All right, have a good night.